still going on, and actually, we're set for some hearings.
So you think you go on another 10 years?
We were set for a whole bunch of hearings pre-COVID.
Okay, so it ain't over with then. Okay.
No, we've requested a trial date. We just said, look, if y'all not going to do it, let's just go try the damn case, and then whatever. So.
You know.
All right, I think we're ready to start.
All right.
Sorry, everyone, for the technical difficulties. We had everything set up and ready, and our Wi-Fi just cut out on us. So we are ready to start. We have Sharon, Kyle here, and a special guest with Matt Holmes. So I'll let them take it away. If you have any questions, go ahead and type them in the Q&A, and then I will be monitoring that, and we'll just be able to discuss how to get your company prepared legally. Take it away, Sharon.
Very good. Thank you, Mackenzie.
Yes.
Thank you, guys. Apologize for the technical difficulty. I guess different times. I'm not used to doing these presentations via Zoom, so a little bit of a learning curve this morning. So as Mackenzie said, if you have a question, generally speaking, these things go by a lot quicker, little less painful as we get group participation. So anybody have, if you have a situation that you're dealing with currently, this is basically your opportunity to have a lawyer at your disposal for a few hours. If I don't know the answer, I will get the answer and get it to you after the class. So whatever's on your mind or is concerning you, just you can type those, or during the breaks you can call the Home Builders Association. And what's that number? It's 769 7696. If you can't through technology get your question in, then maybe during a break you can call and do that. As Mackenzie said, my name is Sharon Kyle. I am the owner, managing partner of the Kyle Law Firm. Our law firm primarily practices construction defect litigation. We've been at it since, I guess about 23 years now. I did not start as a lawyer. I started as a contractor and a member of this association. My husband and I have been members since 1992, I believe, showing my age, when we were young builders, and I was a project manager, so I am actually licensed both residentially and commercially, and was a job site superintendent for a company. As I went through law school, I realized that there was very few people in the construction industry that were catered to our company and our type business. We had construction lawyers that were well-versed in the plant work, industrial type construction, but very few people that were catering to the remodeler, residential home builder, and what I would call the small mom and pop shops. So our practice has been primarily trying to keep you guys straight. And, you know, so a lot of times what I'll tell you guys is from a legal perspective, what I want in my perfect legal world, what I want you to do. But I also realize the practical side, having been there, done that, on all facets of the transaction, that we still have to do business. Our primary goal is to sell homes, have clients, make money, and have a healthy profit margin. And so that being said, I know that a lot of times you aren't going to follow exactly what I would like you to do, but to have the conversation about what's necessary and definitely the things that are more important for me to see you guys take an active role in. I kind of try to play to those suits and try to see how we can manage the risk as best we can. And of course, you know, strange times. 2020 is different. As Mackenzie stated, we have Matt Holmes here. Matt is with Holmes Building Material, and I'm going to turn it over to him in just a second to discuss lumber prices, which is going to tie into my need for a escalation clause and maybe some contract changes that may be prudent for you guys, depending on how you're bidding these jobs, how you're putting those bids out, and what you're obligating yourself to, just so you can kind of get a historical perspective. Matt's going to let us know what he sees industry-wide, and he's kind of, you know, been very good about keeping up with current events and those type things. So anyway, we will go over different contract clauses that I think are more importantly in today's climate than used to be. And then we're going to go over some general contract provisions that I think are important. We're going to talk about lien law and how for you guys to perfect your lien rights as a general contractor. What we're seeing now, and I guess it's just the economy, part and parcel. A lot of people are, you know, tired of the houses. They want new things in their houses. They're wanting to upgrade. But sometimes the economy doesn't always go with that. We're finding that builders are having a hard time getting that final payment. So we're going to spend a little bit more time today on how to set it up from the get-go to where we've got our best chance of collecting that final payment and getting that last draw. So, as I said, feel free to have questions and participate, and we'll get you the answer to your question. And with that, I'm going to go ahead and turn it over to Matt Holmes with Holmes Building Material.
Hey guys, my name is Matthew Holmes, Holmes Building Materials. I guess everybody can see me. I'm good. All right, perfect. We are a local lumberyard in Baton Rouge. We service the greater Baton Rouge area, and I am here today to kind of go over what the market outlook is like, and then tying back onto the legal standpoint of why you may want to think about an escalation clause in some of your contracts because of what that market has been doing over the last 6 months. I know every builder in here knows and understands that prices have been going up, right? I wanted to give a little bit of a background on how we purchase lumber to allow y'all to understand how that affects y'all as the end consumer for us, as well as what the market has been doing. So there is a publication called Random Lengths. Random Lengths is what every mill goes off of whenever they go to sell us lumber. Lumber is traded on the open market in Chicago, so it fluctuates just like the price of oil and gas would fluctuate. The higher the demand, the higher the price would be. The lower the supply chain is, the higher the price would be, right? So when you have a low supply chain and a high demand, then you exponentially increase the price of lumber. What has happened over the year 2020 is the bottom of the lumber price was about April or May. During that time was when coronavirus was getting kicked off and states didn't know what was going to happen to construction. So these big mills are reacting to scuttlebutt on the street saying construction is going to be a downhill slide this year, right? So then they're going to cut back their production. They're not going to necessarily lay people off, but instead of producing 24 hours a day, they may only produce 18 hours a day. Well, them cutting production is not, I compare it to turning a cruise ship, right? It doesn't just turn overnight. That may be a 2-month plan for them to be able to cut production to get where they think they need to be. Well, during those couple of months, what happened was everybody sat around their house and came up with projects to work on. Fencing was one of them that if y'all tried to buy fence boards, they're better now. But if you tried to buy fence boards 3 or 4 months ago, they probably did not exist. They were as expensive or as a high commodity as gold would be. People sat around their house and they worked on their house. And then what happened was a bunch of states deemed construction a necessary work environment, so they did not get shut down. So actually construction has thrived through remodels and home renovations as well as new construction because of interest rates. So instead of cutting production from what the mills were doing, they really should have been ramping production up, but they went for about 60 days of cutting, then trying to ramp up, and they just never could keep up with demand, which then the supply is low, the demand is high, it's going to increase pricing. At some point, the price is going to get too expensive and people would start saying, I'm going to wait, I'm going to wait, I'm going to postpone. When enough people say, I'm going to wait, that means that the builders aren't building, that means the lumberyards aren't buying, that means the mills then have a surplus of inventory, which they're trying to dump, which would bring the price back down. Well, what happened was extremely low interest rates. So when we told somebody a building package was going to be $50,000 in April, and now it's 65 or 70, they go, oh man, I don't get anything for that. It's the same 2 before, it's the same sheet OSB, but the interest rates are 2.5% or 3%. I got to go ahead and build because I'll make up that money over the life of the 30-year mortgage. So the demand never went down when it should have topped out, and the price should have topped out. It just kept going. So you wound up with historical highs higher than it's ever been. Random Links is the publication that gives us as lumberyards something to call the mill and buy material from. So everybody's heard, you don't use it very often, but you've heard of prices per thousand board feet, cost per thousand. That's still the way that we buy lumber. That's not necessarily the way that we sell it, but it's the way that we buy it. So we call up a mill and we say, Random Links is at $600 a thousand right now. What will you sell me a truck of 2x4s for? They say, well, we'll sell it to you for $600 a thousand plus whatever freight we have in there, that's fine. Which just means the market is flat. If Random says it's 600 and I'm buying it for 600, the market's flat. If Random says the price is 600 and they say, I'm going to sell it to you for 625. Well, then you go, ooh, I'm paying more than the market price. So then the market must be rising, right? And then we have to determine if we want to buy that. Usually when they're getting premiums, there's no negotiating. There is no like, well, I'll buy it for 610 instead of 625. When the market is falling, that $600 a thousand price, they may say, I've got too much wood on hand, I'll sell it to you for 585. Usually when the market's falling, then there's room for negotiation of, I'm not going to pay 585, I'll pay 575. We got a deal. So that's how we go to bat buying material, which then in effect is the same way that y'all go to bat buying material, because I make the same margin, my cost just varies, right? So if my cost is going up, then the price is going up to the builders, to the consumers. If it's going down, it's going down. So what's happened, I have some numbers, because if I give you a number of 900, 1,000, or 600, 1,000, that doesn't mean a whole lot to a whole lot of people listening. But if I give you some perspective on what it used to be to what it is now, and how that reflects to an actual board or a sheet of OSB, it makes a little bit more sense. So right now, Random Links, every week they produce on Friday a publication that says what we're buying lumber for. And it says what we bought lumber for last week, which is pretty easy to find out, what we're buying it for now, and what we bought it for the same time period last year. So there's 3 numbers that are like a good telltale sign without getting into the minutia of 20 pages worth of information of like, where are we going, right? So as of last Friday, they separate lumber 2x4s to 2x12, and they separate panels, which would be plywood or OSB. This is a conglomerate price, so it doesn't matter if it's spruce or pine, or if it's plywood or OSB, but it just gives you some historical perspective. So right now, lumber costs $760 a thousand, $760 a thousand. Last week, it cost $840 a thousand. So we're on a downward trend, right? Which everybody has probably heard if you've been talking to lumber yards and your customers and things like that. Lumber is going down, OSB is going down. The question is, how far down does it need to get back to where it usually is? This time last year, it was $353 a thousand. So it went from 353 to currently you're at 760, right? So that's a huge number, right? Panels, so OSB, plywood, the conglomerate of any kind of panel good. Right now it's 724 a thousand. That's 1,000 square feet. That's how we measure panels. Last week it was 752. It's gone down about $30 a thousand. That's great. This time last year it was 334. So that's a huge swing. Now, just as a perspective, how quick it goes up and how quick it goes down. In 11 days from print, so for the past 11 days, panels have went down $52 a thousand, lumber has gone down 178. So if you equated that to a 2x12, 16 foot, most people probably know what a 2x12, 16 foot costs or around about numbers, right? So in 11 days, a 2x12, 16 foot has gotten $5.70 cheaper from when I was buying it before. A sheet of OSB has gotten $1.68 cheaper in 11 days. Now, when OSB is $22, $23, $1.68 isn't a whole lot, but at least you know in 11 days it's gotten a little bit cheaper. Now, keep in mind, depending on where you buy and your communication level with their salespeople and the lumber yards and all of that, it takes a little bit of time for all this coming into effect. Because I may have 30 days worth of inventory on the ground or 2 weeks worth of inventory on the ground. In a high market, I can tell you nobody wants any more inventory on the ground than they absolutely have to have, right? Because you need to be able to turn that inventory over when it becomes a lowering market or you're gonna hedge your bets the wrong way, right? So back to my April as a low point, and when I say it's a low point, a historical average, April is normal. It wasn't low historically, it's just low in this rise, right? So a normal price in April, 6 months later, if you take a normal price at the end of September would have been the most expensive lumber is going to be, right? So from April to end of September, that same 7/16 OSB would have been about $11 in April, and it'd be about 26 the end of September. That would have been my sell price to a normal customer. That 2x12 16 foot would have been about $20 in April. It's about 32 at the end of September. So y'all know how much OSB you use on a house. You know how many 2x12s you use on a house. These are huge numbers that that a lumberyard can't possibly just absorb. Hey, I'm just going to charge you $20 instead of 32. Like it's everything that we do is a commodity. So we make our money when we buy it very well, not when we sell it. Everybody's going to pay the same amount for a 2x4. You go to Lowe's, Home Depot, Homes, wherever you want to go, right? So we're not going to get twice as much as someone else is going to get for a 2x4. You make your money whenever you buy it, and hopefully you're buying it a little bit better at the right time than someone else is. So with that being said, during the time frame of June, July, August, September, we were holding pricing, which we would usually hold for 30 days, if not 60, just depending on if it's a flat market, I could hold it for 90 or 120. We were holding pricing for 2 weeks. We never hold pricing for 2 weeks. Usually it's always longer than that, because if you're a builder, how often do you quote a job and you start building in 2 weeks? That never happens. You've got a 6-month process probably between everything that's going on if you're building a custom home for an end user. If you're building a spec home, it's a little bit different. But think about it, if I gave you a quote in April and you decided to start that in September, think about how upside down you would be if that was a hard money contract. I'm going to build a house for $500,000 or for $300,000. And you're now spending over double on a sheet of OSB. What are you going to do from that standpoint, right? I'm not the one telling you what to do. I'm just the one telling you you need to be prepared. Sharon's going to tell you what to do. Okay. I have a suggestion, but she's much smarter than I am. So I'm giving you historical data that will hopefully scare you into doing whatever Sharon is going to tell you.
So Matt, I mean, forecasting out, I mean, that's, 6 months, I mean, that's crazy kind of numbers. I mean,
Right.
we're talking about more than double. What I'm seeing on the inside is the people that, of course, gave the price, they have a hard money contract, and they're in trouble. I mean, their framing package, I mean, all their profit
It's gone.
It's
It's
gone.
eaten up in a framing package.
It's done there before they even have contingency one.
Right.
And we all know how that works. So, how long, or what do you see as far as normalization, getting back to, year ago type prices? I mean, I know you don't have the crystal ball, you don't have that, and it's, I mean, you just shared what 11 days did. I mean, I get it.
Right.
But are we talking about a year thing, or, 2-year thing? I mean, how long do we anticipate this is gonna last?
So what a lumberyard is always gonna look for is like, where's the time to buy, right? So, because we wanna buy as much as we can, as low as we can, and then obviously you wanna sell it when it's a little bit higher, right? If you sell it and it remains low, that's okay too. So historically, your right time to buy is somewhere late January through late February from a lumberyard standpoint. Because think about it, you go back to supply and demand, anybody up north is not pouring, is not framing, they are not roofing because it's just way too cold. So then you knock out half of the supply of anyone up north, right? So down here, maybe it's hunting season, maybe it gets a little wet and it gets a little soggy, so maybe it's a little hard to frame, but just you push through it. It's not the end of the world, right? Some of the lumber that we get could come from Canada, it could come from Europe. Southern yellow pine is more of a regional matter, but some of those other ones, if it's coming from Canada, they're trying to sell it to anybody before they get it down here, right? So if there's nobody to sell to it up there, and those mills have to run, then the price is going to be historically a little bit lower. Now, is that number going to be back in the mid 350s next February? It's not. Like, there's going to have to be a new norm, right? I don't think you're going to get back to OSB being $9, $10 a sheet anytime next year, because about the time it looks like it, maybe it gets down to $13, $14, and then it's going to be like, there's the bottom. Now we're going to go back up because it's going to be springtime and demand's going to start to kick in from you guys up north. So I think it's just a little bit of a new norm in 2021, and that may not be what builders are used to, but all a builder wants to do is just like, tell me what the price is and remain at that number. And then everybody's going to be covered, right? It's just a hard thing to do from a lumberyard standpoint. And we've had to back out of contracts with some big commercial guys saying like, it could be a $200,000 job and it turned into a $350,000 job. And then we just said, I'm sorry, I just can't sell it to you. Well, you signed a PO. Okay, but I can't sell it to you for that on the PO. So what do you do type deal, you know? So we've because the market has done what it's done, it's gotten us in trouble, it's got end users in trouble, it's got a spec builder in trouble who they're only going to be able to sell that house for $200 a foot or whatever the number is, right? Because the banks aren't going to appraise it for any more than that. They don't care if the lumber went up. So then who's getting squeezed in this? The contractors, the guy in the middle gets squeezed, right?
Well, and that's exactly what we're experiencing. I mean, our appraisals, just because the lumber has gone up, it does not equate to value in the appraisal. So we're having appraisal problems. We're having fixed price contracting problems. You know, the contractor, that's all their profit that's in the job. And so obviously I think that our members have to be prepared to try to hedge their bet in some certain way, because I don't think, it doesn't sound like they're going back in with the 350. And, you know, so it's gonna be in between that 350 and that 750 or 800 range, right?
Yeah.
Which percentage wise, I mean, what I'm getting, I mean, it's a big deal. It's a big deal, and to these guys' bottom line, you know, they've got to figure out how they're gonna contract around it. I mean, just like you say, you know, the end user
And then the question is too, so it's a custom job and it's a hard money price, and you quoted it at the end of September. The builder turned in bid at the end of September, and he's gonna plan on building that in January, February, maybe? Well, he's going to be way better off in January and February as opposed to the time frame that he quoted it, because that was as high as it physically could be. So you do have the reverse of that happening as well. And then if that's a hard money bid, that's fine. If is somebody really an educated end user, an educated client, are they really expecting to pay the same in January, February, as opposed to in September when that's a hard money bid? I don't know that answer. If I knew anything about the market at all, so like, I mean, because this is like national news, how high lumber is, right? Well, it was nationally as high as it's ever been, and you quoted my price in September, and now I'm going to build it in February. Like, are you giving me some kind of discount, or like what's going on here, right?
So are you having your clients rebid it? I mean, are they coming to you and saying, you know, here's my September bid, you're quoting it, you're doing it for 2 weeks. Are they then coming back to you in February, or are they just kind of running with their
No,
September?
so they'll look, usually we'll do an estimate, and we'll say for this materials, it's gonna be this much money, right? And everyone knows that estimate is great for a budget number, but it doesn't mean a whole lot, because no one's gonna build, even if we're holding numbers for 30 days, no one's building in 30 days, right? No one is. So then the builder, once he says, yep, I have the job and guys are going to the bank and we're starting to do dirt work and I think we're gonna form in 2 weeks, then he should come back and say, hey, update my numbers and let's see where we stand. Good, bad, or indifferent. Right. You know, and it may just be, well, the market's been flat for the last 4 months, so you can use the same numbers, no problem. Well, that's easy.
It may have gone down.
Yeah.
You know, just depends.
Well, in the September to February example, it's going to go down. And then, you know, however you want to handle that savings from a builder standpoint is how they want to handle it. You know? But just as easy as it goes down, it goes up. So if I'm a builder and I'm bidding something in February, March, April, and I know that's not going to start till August or September, I'm putting some kind of fat in there. If I don't want an escalation clause, you better mark it up, which most builders, I feel like when a lumberyard gives them a bid, they're going to mark it up somewhere between 5 to 10% anyways, because there's no telling how much material. We're going to figure it in a perfect world on a computer, not necessarily how it gets framed and wet in the field, right? So they already have kind of a fudge factor in there to try to stay safe. That fudge factor may need to be a lot bigger, or you just may need to come back with the escalation clause and say, look, this is exactly what it takes to build a house. Here's the escalation clause. If I'm a builder and I would ask the lumberyard, hey, if you went up from $20 to $32 on a 2x12, then can you prove, like, what's the correlation between random lengths that's publicly traded? And if I can prove that it goes up about the same percentage, then I go back to my end user in that escalation clause and say, I'm sorry, man, this just went up 8%. And maybe there's an over-under of like 5%, where the builder or the lumberyard eats it plus or minus 5%. Maybe it's just not worth the headache and doing the paperwork. But if it's anything over that, then it goes back to the client and it gets added on. And worst case scenario, if 5% is the over-under and it turns out to be 7%, and the builder thinks the client is just a great person, it's gonna be a great job, you can always just be a good guy and say, hey, I'm not gonna enact. Yeah, that's correct. Or you have an act now at this point. And then the other question is, we're talking about unit pricing, right? Like a 2x12 from $20 to $32. Well, what happens when we give you a $50,000 package and the unit prices all remain the same, but you use 15% more lumber on that job for whatever reason? Is that poor management from the lumberyard standpoint? Is that poor management from the builder standpoint? Or does that get passed on to the client through the escalation clause? So is the escalation clause based upon more of like a market and a unit price, or is it based more upon like usage on the job?
Or a bidding strategy.
Correct. Correct.
And a waste factor. And
Right.
what you're saying is that most builders, we always have that 5 to 10% contingency, or most of us do, waste factor, you know, those kind of things. Not so much unit pricing, but from a material usage efficiency
Correct.
standpoint. But you can set yourself up for a double whammy here. I mean, you know, you got a usage, you got unit pricing, and in a perfect world, you know, sometimes it offsets, but
Sometimes it does.
sometimes it doesn't.
And we've had some builders ask like, hey, I need you to throw in, like I know on my walls, I always use more studs than you estimate. So could you just give me a little like a little allowance in there?
Right.
Or rafters are another one that's hard. So we may have a rafter package of $5,600 and throw in $1,500 more that just says miscellaneous rafter material, because we know there's going to be scaffolding built all the way around the house, and we're not figuring for something's going to happen, right? So we've had some builders request that, which it's a line item on our bid. So if you don't want that, then just don't use it, right? But if you do want that, and you've got to show that bid to the end user, say, look, I know the lumberyard is going to figure it on a computer in a perfect world, so I've asked them to put in a little bit more money on walls and a little bit more money on rafters. If we don't use it, I don't bill you for it. If we do use it, that's why it's in there. You know, which that's not a bad strategy to have either. But at some point, you got to worry about like, you add here, and then the total price is just too expensive.
Well, and that's, you know, that's our balance, right? I mean, we're trying to get the job.
Right.
Ultimately, we're trying to get the job. We don't want to price ourselves out of the market. So, you know, do we show it as an allowance for these people? Do we have an escalation clause? How much fat do we put in there?
Mm-hmm.
You know, because that ultimately, that client, you're giving them the thing, and it's $500,000.
That's all. Bottom line.
You know, that's what they see, and that's what they reconcile in their mind. It's $500,000. So what do you do? And you know, Roddy just gave me a price for $480.
Yeah.
So I'm going with Roddy.
Yeah.
You know, I mean, it's just.
And the devil's in the details.
And the devil's in the details, and he may not have done the 5 or 10% plus the 5 or 10%.
Yeah.
And so there's your 20%, there's your money. And so I think it's hard for the builder to, one, maintain their competitive edge, and then 2, protect themselves. And so those are some of the things that we'll kind of talk about, whether you do it with an escalation clause, rebid, knowing your numbers, you know, is an allowance item rather than an escalation. Do we do that cost plus, you know,
Mm-hmm.
how we do that? But very interesting. I knew obviously it's in the news. I'm dealing with it on the back end of clients going, how do I get out of this? I mean,
right.
I bid this job. They waited to start. I mean, plans that's how it works. I mean, it takes us a while.
It always does.
And all of a sudden, it's like, I mean, you know, a $50,000 package is now $7.
Mm-hmm.
And they're like, I don't have that money in the job.
Right.
And they want to go ahead and go. Can I wait? Am I going to be in default of the contract? So, you know, we're having some growing pains around that. And I think what I'm hearing from you, Matt, is that it's not going to go away.
It'll get better than it was 2 weeks ago,
Right.
but it's not just going to go away. So we got to figure out some way to work around it. You know?
At least for the next year too.
Right.
Well, Matt, I'm gonna throw something at you that as a builder that I've been hearing, that's worse than the price increase, unavailability, just not available.
So personally, I have projects around my house. So I personally have heard that from people working around my house, as well as anything that is being manufactured. Lumber, because it's a commodity, and if you've never been to a lumber mill, it's extremely interesting. I mean, you could have a mill that produces OSB 24 hours a day. There could be 6 people working at it because they're all behind computer screens, watching, monitoring, and it's all machines doing the actual work, right? COVID doesn't strike those places very bad. Like then there's less people working there, right? We've had problems like vinyl windows where you have a ton of people in a small area that's hot and enclosed. Vinyl windows have been a mess. I don't know if everybody's experienced that or not, but that's one. I've heard any kind of machinery that's getting made. I've heard problems with AC units. It's not my field, but that being hard to get like heating elements and things like that. So if whoever you're talking to says it's a 2-week lead time on this special order, then you ought to give yourself some more time than 2 weeks, because it has been a challenge getting anything that's being manufactured. Sheetrock would probably be sheetrock and insulation are the one thing that hasn't been terrible to get. But whether it's roofing, windows, doors, that's the products that I know very well that have been a struggle. Lumber shouldn't be hard to get. At one point it was a little tougher. Lumber shouldn't be a struggle to get. Fence boards shouldn't be a struggle to get. So those things should be calming down a little bit.
We are seeing with the Windows appliance packages, those type things, ovens, you know, a lot of what the remodel industry, you know, people updating their homes, those type of, freezers.
Yeah.
You know, everybody went and they thought there was going to be food shortages. You can't find a freezer in this town. You just go try to find an upright freezer. I mean, who would know that kind of stuff? But you know.
But that could hold up a builder from getting their last straw or getting their blackened straw if your windows don't come in or whatever. You know?
Ovens, dishwashers, all of those appliance packages, which, what do we need? I mean, we're gonna trim that out, and that's on our back end, and that's how we're gonna get finished and get paid. And the lead time on those kind of things it's just, it's nuts. I mean, they're back ordered, they're out of stock, you know, so we've got a timing issue. But I think it's because they are more maybe labor intensive. I think they're a little bit more effective from the COVID.
It seems like that coronavirus and COVID is a really good excuse to have really poor service in a lot of things. You know, anything, oh, that's delayed, must be COVID. Like, this is going wrong, must be COVID. You know, can't get delivery, I remember that guy had COVID. You know, so that will be an excuse for a long, long time, I think.
Exactly. All right, well, any other questions of Matt? Do you have anything?
Nothing on Zoom so far.
Okay. All right, well, I certainly appreciate it.
Thank you very much for inviting me. I hope it's been informative and helpful.
It was for me, for sure. Sure. So I will probably need to be in touch.
No problem.
Over all this as we try to figure out the best way to kind of contract around some of this stuff.
Okay.
We have one, I think.
Okay.
Amy. Amy, you should be able to unmute yourself.
Hi, guys. We have a few people here in our classroom listening to the presentation, and the question that was just asked was whether or not he anticipates lumber prices coming down in the near future. Is that the question?
Yes. I mean, they've already, in 11 days, they've already come down. They've topped out. If you are looking to build, we have some builders right now that have slabs on the ground that are asking the same thing. Like, what do I do? I got the slab on the ground. Do I just need to hold off for a little while? Because right now I can. Or what am I doing? The longer you can wait, the better off you are. So if you're going to plan on building this week, I would say, why don't you wait till November 1st, assuming that your lumberyard or building material supplier probably updates their pricing on once a month on the month, right? A lot of people have asked, well, do I just need to wait till February until prices are cheaper than now? Yes, prices will be cheaper in February than they are now, but can many builders not build a house for 6 months and still be okay? Usually that answer is no. They need to keep with product on the ground. And right now is not a bad time to have a house out there because they're selling pretty quick because interest rates are low. But the question is, you're just not making very much money at it because the prices are real high. So yes, the numbers will go down. They won't go down as fast as everybody likes. And you may or may not have seen that reflective yet in your pricing from your local lumberyard. That number may still be the same because they just need to get rid of their 2 weeks worth of inventory that they had, and they're waiting until November 1st to reprice stuff to be able to get a little bit better of a number. So the last thing that any lumberyard wants is to get caught with too high of a number, especially in a strange market like this. So yes, it will. What that number will be, I can't speculate it, but the longer you can get closer towards January, February, the better off you're going to be.
Anything else, Amy, from your group?
Yeah, I do. The question is, what does it look like for roofing and sheetrock and other products that prices are going up while some people are kind of waiting a little bit for lumber prices to go down?
That's a really good question. So anything that is not traded openly, like lumber, and that is not a commodity like lumber, is typically going to have announced price increases. I would love to tell you that that's once a year they'll have an announced price increase, but every now and then people will do it maybe, at quarters, right? First quarter, second quarter, third quarter. Right now, roofing had a price increase, depending on your brand. Usually when one brand goes up, they all kind of follow suit. So most roofers had a price increase about 20 days ago. But in the states of Texas, Louisiana, Mississippi, and Alabama, because of the natural disasters, the companies producing the roofing cannot enact that price increase as long as it is a current location. So somebody from Oklahoma can't come open up a roofing yard and take advantage of a 5% decrease in pricing, right? So that's helped on the roofing side, or otherwise it would be a 5% increase. So keep in mind, most of these increases are announced 30 to 60, 90 days in advance. Like we have some price increases coming down the line for insulation, but they're at the end of January, right? So like we can prepare for that. And usually those increases are more along the lines of anywhere from like 2 to 9%. So it's not huge, and that's not on every product category and things like that. So that's a little bit easier to swallow. Sheetrock just went through a little price increase. But once again, you're talking about $10 a thousand, maybe $15 a thousand. And so, I mean, you're per sheet, that could be 20 cents, 15 cents. It's just not a lot. So most manufactured things are going to have preset dates on increases where commodities aren't. But once again, if you're changing years, I quoted this in November of 2020, and I'm going to sell it in 2021 in February. You're probably going to have, although lumber may be cheaper for you, you're probably going to have some price increases that hit because a lot of people do it for first of the year. So your windows may have gone up 3%. Your appliances, which I know nothing about, but they could have had a price increase because they're manufactured just like everything else. So that would be the only thing. So that's just staying in touch with your material supplier and knowing what the next, because they'll know like in the next 3-4 months, are we going to have any price increases? They should be able to tell you that.
We had John Jordan ask, any guess where the new normal price of lumber will be?
Man, if I knew that, I'd be a really smart person.
Right.
And it depends on what the lumber is and the availability. Spruce is going to be different than pine. It's going to be different than OSB or Euros. So I can't tell you what the new norm will be or what the bottom will be or anything like that. If I could, I probably wouldn't be doing this.
Anything else?
Amy, do you have any others from your group?
No, I don't, but thank you.
Perfect. I think that's it that we had from the Q&A for Matt.
All right, guys, thank y'all very much. If there is anything I need to do or y'all need to reach out, I'm sure you can share my contact information.
Yep.
We'll be fine with me. That's no problem at all.
Just your email?
Email or something.
Perfect. Yep, I will send that up to them.
Perfect. Thank you, Matt. I appreciate it.
Sharon, thank you for having me.
Yes.
Thank you, Matt.
So I guess with that, we'll go ahead and let's take a 10-minute break. And then we'll get back and kind of start talking about ways to kind of contract around the information that Matt just gave us. Okay? So. I need some coffee already.
You can call us back, Mackenzie.
Yeah, it's, I haven't started.
Just tell them if you have a question.
Miss Sharon, am I gonna mess you up if I talk to you a little bit?
No, come on, talk to me.
Okay.
Keep me awake.
All right, we are back. If you guys have any questions, you can either type them in or raise your hand in Zoom, and we can unmute you so you can answer live. Or ask live, I should say.
So I know we're going to go ahead and talk about some different contract clauses that I want you guys to do. We're obviously going to pay attention to the payment provisions, lien law, escalation. We're going to talk about some cost plus and some allowance stuff to specifically address Matt's scenario, lumber prices, increased building prices, supply shortages, all of those kind of things we're having that affects our timeline, our delay damages, and those kind of things. So we'll talk about those. I know from my folks in Acadiana, when I usually do this class, I usually start off by saying, you know, how do you lessen your corporate liability? And as many years as I've been doing this, it never ceases to amaze me that some people are still contracting in a non-incorporated entity, meaning it's Sharon, Kyle, whatever, you know, doing business as. So you know, there's corporate laws that are designed to set up to where you have personal protection against these things. You know, gosh forbid, you don't need to be out there contracting in your personal name. I mean, you just don't. In this day and age, I shouldn't have to say that, but it's amazing just how many people do not have an incorporated entity. It matters not to me whether it's an LLC, an incorporation, an S corporation. That's usually more of a tax determination. That's a question for your CPA and your lawyer to figure out what the best structure is for you. But you know, the courts are very reluctant to find personal liability on the part of a principal or an owner that has taken the time to set up the corporate structure and act in the manner of a shareholder. So, you know, there's a few things that can happen that can mess that balance up. The courts really look at it, it's gotta be egregious. I mean, you know, there's a few factors that we have that they'll kind of say, you know, that you're not really running a complete company. So, you know, from a standpoint of a LLC or a partnership, those kind of things, corporation, you are required to have corporate formalities. That would be your inks and your COs. And you're required to have an annual meeting, shareholders, that kind of thing. My husband and I, way back in the day, our general construction company is a CO. And, you know, that sometimes is hard to keep up with because it's just, we're a mom and pop, and, you know, so I'm required to have these meetings. Well, basically, you know, at the end of the year, we just say, hey, how's life? Great, fine, here's our meeting minutes. But you are required to keep up with that paperwork and do that. So it's one of those things that doesn't have to be in depth, doesn't have to be a whole lot, but if you have that structure, you need to make sure that you're following the rules. An LLC, limited liability corporation, does not have the formal requirements of the paperwork. So you incorporate or you form that company, you're a member, not a shareholder. That's just the basic designation of the distinction. But you don't have any formalities. There's no meeting requirements. There's no whatever from year to year. You just pay your $25 to the Secretary of State, update your records, and you're good to go. Okay, so you have that personal liability. There's a few things that the courts have found that can, what we call piercing the corporate veil, or you know, that they look at. It's a 5-factor test. Commingling of funds. So, you know, to the extent that we don't need to buy our groceries and our gym membership and all of those kind of things in the construction company. We don't need to pay our kids' school tuition, those kind of things. Just be mindful of not using everything from a company purpose to benefit your personal situation. Failure to follow the statutory formalities of incorporating and transacting your corporate affairs. We just talked about that. It's general, not very, the requirements are not stringent, no big deal. But if you have a problem with paperwork, you might want to lean towards the LLC. Undercapitalization, I've always found this factor to be kind of interesting as it relates to construction companies, because I don't know really any construction companies that we don't keep our capital, generally speaking, in our checking accounts. I mean, we make draws according to what we have going on, whether it's a slab draw, frame and draw, whatever, we pay out our bills, you know, you finish up the job and you take your profits. So it's not like, there's not a whole lot of construction companies that are sitting around with just hundreds of thousands of dollars sitting in their checking account. We put the money in, pay our bills, we take what's left as our profit, and that's how it is. What they mean by undercapitalization is kind of the shell game, meaning I'm just going to bleed this thing dry. I'm creating this corporation to build out a subdivision. It's going to be ABC Corporation. That's who the builder is. We're going to build all of these houses. You know, we're finishing up, and I'm taking every red cent out of the company, and basically, to the extent that it looks like I'm not prepared for my warranty obligations, or I'm just going to let that company go by the wayside, you know. So that's kind of where they're looking at it. It's more of an egregious type thing. It's not just that you're day-to-day living and you're paying your bills and moving your money out of it. Failure to provide separate bank accounts and bookkeeping, that kind of goes along with the commingling, kind of goes along with the, you know, paying the gym membership and those kind of things. Where we have to be careful, and I've had a couple of builders get in trouble with this, is the definition of misappropriation of funds from a contractor's perspective to the owner is fairly stringent. It's traceable. You know, it's like, okay, well, if I get this draw and it's through Black-In, right, then supposedly that purpose is for my framing material or whatever is included in maybe that bank draw listing. And so sometimes if you take that that draw, and we all know, let's talk about the slab draw for a second. We take that slab draw, you're getting paid more than that slab cost, but there's a reason for that, because you are in anticipation of buying your framing package. They're gonna come drop that out there. You know, it's like seed money to kind of get started. And so you just need to be mindful that if you're not paying the diggers or the concrete or whatever, you got that draw, and that scope of work was included in that draw. And so we want to make sure that those bills are getting paid, because you certainly don't want to have an owner come back on you and say that you misappropriated funds, because it's a civil penalty and there's a criminal penalty for it. So it could have some serious implications on how you apply that. And then your failure to hold shareholders or directors meeting, again, that goes back to your corporate formalities. So, you know, other than that, just make sure that your corporate structure is set up properly. Make sure that it is, you keep it current at the Secretary of State. It's online, it's $25, and you would be amazed at how many people we go, when we're in a lawsuit and we pull up all the documents, and it's been revoked by the Secretary of State. You can reinstate it, but it's not in good standing for failure to follow this annual report. And there's no reason for us to take a chance on personal liability when it's a click of a button and it's $25. But there again, that's my perfect world, and you gotta do the paperwork in order to kind of protect yourself. So any questions on the corporate formalities or difference in corporations or any of that?
I don't really have any questions, Sharon, but just kind of on what you're talking about, just some issues we've had. Everybody wants to stay in a good standing. Probably in the last 10 years, we don't get invoices the old way where they just mail them to you. They'll either email them or text them to you. Sometimes we don't get those invoices. And so we get a phone call, you're 60 days late. We never got anything. And obviously it gets corrected, but there needs to be a better way. You know, give us the invoice and we'll pay it, because we want to be in a good standing. I'll let someone else deal with that, but I know I'm not happy. There's so many times that we don't get the invoice.
Well, and you know, that's interesting, because we also have situations where, you know, technology is a wonderful thing, but it's not foolproof. And, you know, what we end up having is a lot of times we're trying to go get that final draw. We're trying to get our payment. We're doing our change orders. We're trying to submit that final bill or that invoice for these folks, and we don't have all of our bills in. And, you know, so what happens when all of a sudden you think you have all your stuff, you send that final bill, and this is just the way it goes, then, you know, they say, oh, well, hey, you're 60 days late on this. You've kind of already closed out the job. And these homeowners, you know, once they move in, and once, I mean, it's it. In their mind, they've closed out that contract with you. Doesn't matter that, I mean, it's their invoice, it's the cost of their job. They then want to come back and try some type of justification. I mean, that's just what we find, human nature. They try to justify, well, I mean, I closed out my loan, I could have borrowed the money, and now I can't borrow the money, and I don't have that money, and so you should somehow eat that. So it causes a timing issue sometimes for us, as far as getting that final payment. And the only thing I can say to that is, you know, I guess that's the benefit of using those same vendors all the time, getting it down to where you don't have those billing inconsistencies, you know what I'm saying? It's going through to the right email, it's not going to spam, it's, you know that you're getting that homes building material bill on the 1st and it's due on the 10th. I mean, so you know where to look for that.
We have a tendency to address everybody in our circle as they're all good people and they're reliable, and we're happy about that. But every now and then, we'll get a sub or somebody that won't pay their bill, and we have no knowledge of that until that lien is applied to our job site. That's when we have knowledge of it. Then it's got to be dealt with.
Well, and especially in light of the fact that you have someone that maybe you have to terminate on the job, or that doesn't finish their trade. You know, you have a painter pull up, or you have a sheetrock guy pull up, or you have that. Well, what do you owe? You know, and a lot of times those guys, sad to say, but the conflict resolution skill set sometimes is just not there, where you would hope that it's a business situation and we sit down and go, Roddy, look, you're not finishing this job. This is what it was bid. What's fair? Let's settle it up and let's walk away. That's not the way it is. And what shows up, you can't get in touch with whoever. You have to go hire a replacement contractor. You go to try to close out the job, and you've got a lien on the job for the original amount. But they didn't even finish. I mean, so it can't be the original amount. But you're left to argue that on the back end. And
Well, this is an interesting conversation we're having, because one of the hardest lessons I've had to learn as a builder is that when I'm ready for my plumber and he says he's 3 weeks out, and I tell my homeowner, we're going to wait on him, and they said, why? I said, because we have a communication about us that can't be replaced. I'm going to wait on him for 3 weeks, and that has worked well for me. I'm going to wait on somebody that I know very well.
Well, and from a quality standpoint, from a payment standpoint, there is a definite benefit to dealing with your same subcontractors. No question. Something goes wrong, that guy's going to be there to take care of it because he's done your work for just that long.
Yep.
And he knows it. You're familiar with how you work, and those things are very helpful. And in that same breath, you have to realize that as a general contractor, we're acting as the general surety for these subcontractors. Now, contractors do not see themselves in that role. But anytime, Roddy, if you go to the cabinet shop and you order that cabinet package, what are you doing? You are obligating yourself, not your customer. You have a contract with your customer that they're supposedly going to pay for these cabinets, but you are ordering them from the cabinet maker. You are creating a contract that you're obligating yourself to pay for these things, whether or not you get paid or not. And that's in every single situation. So you're acting as a surety for the financial stability of your subcontractor. So it does matter who you do business with. It does matter how professional they are. And it does matter how much backing up room and how financially solvent that person is. Because if you have your plumber and you hire him out there and he goes and does all that stuff, you could get a letter saying that your plumber hadn't, paid LCR. And, if you start doing a whole lot of business and, sometimes those guys get behind or whoever that is, and all of a sudden, you're doing a lot of business and they go, oh, well, here's, they owe us $70-something thousand on your job. guess what? You are legally responsible for that amount. It does not matter that you paid that subcontractor. Does not matter. The supplier has a right to lien that job, and you could be forced to pay twice.
Well, it's interesting because when we builders get together and conversate, we try to decide what makes a good builder versus a not good builder. And we've all agreed on one thing: the builder that will go back after the sale and take care of complaints, that's what we're going to call a good builder. Because some of them will not go back.
Right. Well, some of them do not have the wherewithal. And what I find, and I have found in my practice over several years, is that for the most part, our builders want to do a good job. For the most part, they want to be professional. They want that customer to be happy with their product, and they will go above and beyond even what I tell them. I mean, the new home warranty act, we'll talk about that in a little bit. That's our minimum mandatory warranties. That's our baseline. That's what we have to do. I would say that 90% of my builders, they just go do, I mean, if they have a request from their client where they could take the hard line and say, nah, I mean, it's not in warranty, I don't have to do this, they still go do it. They want that customer satisfaction. And that's the, we have to do business, and we have our reputation, and a lot of, I find the builders do take pride in their work and want to have a happy end customer.
I had to learn that lesson the hard way, that is not under warranty. Go back in time, and 3 months after the sale, seasoned oak tree died on the property, and they wanted me to take it down. I said, oh, no, look at your new Home Warranty Act. I'm not responsible for plants. Their attitude toward me wasn't very good, and I wasn't happy with that. So I changed my attitude. It wasn't a warranty, but I took it down, and you're absolutely right. It made me feel a whole lot better. Just, it doesn't have to be under warranty, but you got your name, you need to keep it up there.
And sometimes, it just depends on what it is, and a lot of it has to do with how that customer interacts, whether it's an entitlement or whether they feel like, whatever, and if you want to do something for them. And we'll talk about the no good deed goes unpunished aspect of that, because sometimes, my clients are too good and get themselves in trouble that way, because they go and they try to help, and then it just grows and it snowballs. Did you have a question?
Yeah, when you were saying about the painter, he says you own this and you didn't finish, like how do you legally fix that? They're saying they owe you own this or whatever, and it may not be the case. Right. And they do put a lien or so on, can you find out if there is a lien and how so, or how, you go to a judge, how's that settled?
Right. Generally speaking, the liens are, they're filed against the property. Majority of the time, they're not filed properly. Very few people do lien law. Even attorneys, they mess it up all the time. And so majority of the liens that we investigate that get filed are defective in some way. And so there's a little bit of a strategy of us waiting, maneuvering to where it's not valid anyway.
Does it cash or whatever?
And so if it is valid and we still have a dispute, there's a mechanism that we can bond it off, that we can put some cash aside, and basically saying, I find that he who has the cash kind of wins, right? They're trying to force a negotiation with you, and hopefully wanting you to maybe overpay just for get rid of it, right? But there's mechanisms that we can slow them up and combat those type things. and get it to where, no, that's fine. If you want to fight about it, we'll fight about it. We'll park our money over
It's
here.
almost like you
And
were-
then if you want to be reasonable and we can settle this up, we can do that. But if not, I'm going to go on about my business.
Because that's kind of happened to me recently, was this criminal, I guess, thinking, you know, you deserve more or something, but the situation, you know, wasn't positive, but, you know, I can't continue, so.
Right. And it
It
happens.
was more like a threat, like, well, I'm gonna do this, whether it was done or not, I don't know, and that's why I'm curious, because that's the last thing I need is more work.
Yeah, you can always check the public records, and it generally is not going to even come up until closing. And if you're closing, if it's a spec house or they're refinancing or they're going from their construction loan to their permanent, then the closing attorney will say, hey, Joe Blow Painter says he hadn't been paid.
Right.
You want to do whatever and say, no, I got a dispute with the guy. I'll give you the $3,000 and you can put it in your escrow account and hold it just to know that I'll work it out. But once you take that threat off the table or the imminent, you know, that kind of thing, you have a lot more negotiating room. And so there's ways to kind of get around that. But it happens all the time. Happens all the time. You know, we've got subs in and out, and especially now, I mean, we've got labor problems. We've got supply problems. We have labor shortage problems. I mean, we've got the scheduling, you know, people are out, it's shorthanded. You know, is it gonna take them 3 weeks? Is it gonna take them 5 weeks? I mean,
Right.
so those are all the things that we're gonna have to, in our new normal, we've got a contract around. We've got to make sure that we don't have time frames. We've got to make sure.
Kind of have to figure that in somehow,
Exactly.
know the unknown.
Exactly. And it's just a different time. I mean, you know, from the employment side to the payment side, to the supply side, we're just going to have, I mean, and you know, look, it's just like anything else. I mean, we had, in 16, we had the flood issue. We had Chinese drywall. We had, I mean, throughout history, we've had these things that we've had to adapt to. I find that our builders are very adaptable. It's just that sitting down and taking care of it, making sure it's set up. Traditionally, we're not good paper people. So that's, you know, if I can get that builder, if I can get you guys to just take that time right now to get it all straight going forward, then I think you can kind of save some headaches on that. So, so that being said, I mean, we've got to do our contracts. And again, this goes back to even the corporate formalities. People are contracting without a contract. I mean, nothing in writing. It is crazy. Or it is a one page just estimate. And there's so, I mean, we are selling high ticket items. I mean, think about going into a Walmart and buying a hair dryer. I mean, you open that box up and there's a warranty booklet in that thing, you know, this thick. I mean, we're selling hundreds of thousands of dollars worth of product, maybe $1 million plus of a product. That's, in today's terms, that's not really that big of a stretch right now. And it'll be on a piece of paper. You know.
Well, I'm gonna come at you from the left field, Sharon. You're a lawyer and you're gonna think like a lawyer. Most of us builders, we're just calling people and we're not afraid to work, but obviously we don't have the level of education that we should have. This was told to me early on as a builder. Never ever build on land that's not in our name, the builder's name. never build if it's in their name, because they have all the leverage. Now, as an attorney, does any of that make sense to you?
Your most vulnerable position is when they own the land. Because you're providing a product, you don't control when they move in. It's their property, it's their stuff, and they can move in. There is no closing because you're not transferring anything. So they can go to closing with or without you. You're not, I mean, they're closing on a loan, they're not closing on a title, they're not transferring title. So yes, your most precarious position as a builder is when you do not own the land.
So a scenario, they own the property, they want me to build a house. So should it be smart for me as a builder to say temporarily we're going to transfer that property into my name, or does that not ever make sense?
Well, it does from a protection standpoint of you control when they move in, you control when the title goes back to them. Your downside is now you own a lot. Now you own something that maybe you don't want as a spec. What happens if they die? What happens if they lose their job? What happens if they can't close? What happens if they can't? I mean,
Well,
there's a lot of what ifs.
What if all that happened while they own the lot? It would be a bigger problem.
It would be, but you are getting paid as you go. And if you've got a termination clause, you can walk. You can walk at whatever point you feel like it's going bad, okay? You don't have to finish. And that's where some of these clauses really come into play. And so, you know, from a contracting standpoint, Roddy, you know, we really need to, one, it's got to be in writing, and we got to use the right contract for the right scenario, okay? So what I find and what I see is there's tons of different ways that we can contract. You got a remodel contract, right? You've got a contract labor contract, which I'm calling contract labor. Owner owns the lot. You are providing the contract labor to put that product on that lot. You've got a spec. Somebody's coming up and they're just buying a Roddy Ballard house, right? Sitting there. You got a pre-sold. I'm going to buy a Roddy Ballard Plan C and put it on lot 81 that you also own. Okay? You got fixed price. You got cost plus. I mean, there's all kinds of different ways, and we all do it differently. We all do it differently. I mean, some people love a cost plus. It's just, hey, I'm going to get paid this. You don't have to worry about your lumber prices, because it's a cost to the job.
Well, I was thinking about that when Matt was here. I said, we're not allowed to have a cost plus job going on when it went up like that.
That's right. And, you know, I recently had a situation where we had a difficult client, and the situation came up with the lumber package was just out of control. I mean, it was way, you know, it more than doubled. I mean, it was going to take out, basically, it was going to put these people out of budget. Now, fortunately, our client had a cost plus, so we didn't have to worry about how we were going to get out of or provide the product at the price. But it was one of those things where, hey, it's probably going to be better that we just get out of the situation. And so we were kind of able to dovetail that. But in addition, you need the termination clause. You need to be able to walk at any point in time to see how that's going. So, you know, use the right contract for the right situation. I see people using new construction for a remodel all the time. And here's the thing. Our warranties are different. The New Home Warranty Act covers you on new construction. okay? But a remodel contract does not. Your warranty is what is a stated warranty. And so what we've tried to do and duplicate is put in some of those protections of the New Home Warranty Act inside the remodel contract, because you're free to contract for whatever you want to. So that's where we have to address mold damage, those kind of things. Because if not, if you're just doing remodeling, if you don't have a limited warranty against mold, you're responsible for it. You're responsible for it. New Home Warranty Act provides wonderful protection as far as mold damage, personal injury, all of these kind of things. It's a trade-off. We give them certain warranties and we protect ourselves on certain things. But in the remodel situation, it's not covering you. So remodelers need to be very aware and specific that their warranty is contained in their contract. Let's talk about the escalation clause. So there's a couple of ways you can do it. You can just have an actual, you could put it in as an allowance. Let's say you gave a fixed price contract and you have $500,000. Here's your thing. You're going to put in your framing package to include whatever, an allowance of whatever that is. Okay, it's an allowance item. If it goes over, you know, you can just charge it for what it is. It's just like them going over on appliances or anything else. So you can handle it that way on a fixed price. Cost plus, it's going to be a cost. So that'll run with it anyway. Generally speaking, you're going to give an estimate. So you really need to rely on the MAT of the world and your vendor to update that bid for you, because you do want to be able to go back and say, okay, well, this is what I based my estimate on, and it was 50,000, and today Matt's giving me 70,000. It is what it is.
I hate to ask all the aggravating questions, but as a builder, I see this over and over and over. People will come and they will buy a house to their maximum amount of money they can borrow. I see that over and over. Okay, I'm agreeing with everything you say, but all of a sudden, if that house just rose by $10,000, they can't acquire their financing. So what do? We just shut it down in the middle of the job? I mean, that's not the answer.
Well, and you know, Roddy, we're having to deal with that right now. A lot of my clients on these pre-solds are requiring a little bit more money down, and they are taking out the contingency on appraisal. Because here's the thing, I mean, you know, max prices going from $350 to $750, that is not added on to the value of that house. I mean, you know, just because it costs you $20,000 more doesn't mean it's going to appraise for $20,000 more. It just costs $20,000 more. Doesn't mean that it's worth any more. Now, our buying power, or our customers' buying power, is generally more because of what he was saying with the financing, right? I mean, you got historically low rates, and so, you know, money is really cheap, so they can generally afford more, and that's how people have been skirting this issue, but I think it's catching up. And I think what you're gonna find is those appraisals are not gonna follow suit, and they're not gonna keep up with our pricing demands. And, you know, where you're pricing that house for $500,000, you know, it doesn't mean that it's worth $550 or you know, I mean, it doesn't mean that. So people are taking out on the pre-solds, they're taking out the appraisal factor.
Well, I mean, I've already had to deal with it where, you agree upon a price, the financing is there, the house is 3/4 built, and I don't wanna be negative, but the national home builders come in there and start giving houses away for free, so the appraisals start coming down. If the appraisal isn't there, the banks are not gonna loan the money. So what happens next? They walk. The builder's stuck with a house.
And so that's where we have tried to react a little bit to that, to say that it's not contingent upon appraisal. We get a little bit more down to where if they do walk, you've at least got some money to get that house resold and back into the thing. Generally speaking, you know, Roddy, the more skin that they have in the game, you know what I mean? And they know that they're gonna have to walk from that, that deposit or whatever that is, you know, and they're $5,000 short, they go, do I wanna lose 20 or do I wanna go to grandma and get $5,000?
You just hit a key word there just a moment ago when you said they walk. Okay? Most of us builders are familiar with just a realtor's purchase agreement.
Right.
We're gonna call that a contract. All right, we won't get into those specifics, but the way the realtors explain it, the client doing the buying are not obligated to much of anything. They can walk anytime they feel like it, and they're not held accountable. And I said, well, where's the protection for the builder? They said, there is none. And this is coming from the realtor, this is not coming from the lawyer. And I've experienced it more times than I like to mention. Purchase agreement means nothing for the buyer.
Well, and I will go back to my point exactly. You use the right purchase agreement for what you're doing. Who do you think the realtor's purchase agreement protects?
The realtor.
Who do you think the AIA purchase agreement protects?
Well,
It's an architect purchase agreement. It's not a builder's purchase agreement. They call it a real estate purchase agreement for a reason. And it's not protecting the builder. And that's where, you know, it goes back to the, you know, you're like, okay, well, maybe you're not as educated or whatever, but what my biggest challenge is to get our contractors to realize you guys are professional. You have a skill set that others do not possess. Period, paragraph. Not everyone can do what you guys do. And so we traditionally have a hard time asking for our money. We traditionally have a hard time of saying like we're not worth it. You have a skill set that others don't have, or else they would not come to you to build their house. If everybody could do it, it would be easy and they would do it. So if I can get one builder out of the mindset of, I'm a professional, this is what I'm doing, I'm building you a very expensive product, I'm gonna do it in a professional manner, and this is the way we're gonna contract. I'm not willy-nilly building you $1 million house on a realtor purchase agreement. This is my business. This is my business, and I'm gonna get paid. I'm gonna provide you with a good product, and there's nothing wrong with it. And that's the takeaway of anything you hear today is if you start treating yourselves as professionals and you know, this is how we do it, and I'm providing you a service, and I mean, it is what it is, and I'm gonna get paid for what I do. All I have is to sell is my time. And I know
well,
it's.
Sharon, I've always thought that I was a professional. I just gotta convince them that.
Well, that's right. And how you transact your business and what you will accept, it says that.
I hate to be just naive, but the real estate system said all they need to put down is a $500 deposit, And I said, $500 doesn't carry much value. They can walk away from that. And they said, oh no, you gotta give that back to them if they walk away. And I said, this really doesn't add up. Not really. They can walk away and not lose anyway.
You can't even tax it.
That's right. And so, you know, and those are things where, and listen, we've done from the real estate, the purchase agreement, we've spent a lot of time with different realtors around town as far as we're gonna do an addendum to the purchase agreement, because the realtors are required by state law to write that purchase agreement on their standard form. Okay, so the real estate commission has standardized their forms. Everybody's got to put it on this purchase agreement. And we say, fine. Basically, under other conditions, see attached addendum. And that's where your contract then supersedes all of those arguments. And that's where you're going to protect yourself. And that's where you're either going to have a non-refundable deposit, make it worth, you know, their while. If they want to walk, they can walk. That's fine. If you want to walk, you can walk. You know, it works both ways. So we just want to make sure that you're using the right agreement.
Well, I don't want to discredit the realtors, because we as builders, we need them badly.
That's right.
But somewhere along the way, we're not on the same level. Just like we hardly ever sit down in person to sign off on anything. It's done by way of email. Even now, I wonder how legal it is, because nobody's witnessing you sign it, but that's the new way to do it.
Well, you know, the realtors have, I mean, we've come a long way with as far as the addendums and them understanding the addendums. And you're right, it's a marketing thing. I mean, we have to have them represent us and present our products. It's helpful from a marketing standpoint, from an education standpoint. So that's one of those things that, you know, you kind of have to sit down with that team, you know, and a lot of these builders have gone to using exclusive realtors to where they say, this is our contract, this is what you're gonna attach every time, this is how we're gonna do things. And if you need help explaining it, we educate that realtor on how to explain it to the end user, how to explain it to that purchaser to provide you a little bit more protection than just the standard real estate.
I can't tell you how many houses I've sold that I've never met my new homeowner till the day of closing.
Well, sometimes that's not bad.
And that does not work for me. I like to create a bonding between the people. I need them to feel confident that I'm a builder that's gonna come if they call.
Right.
And that requires face-to-face conversation. And amazingly, that does not happen in place these days.
All right, we have a couple questions coming
Okay.
from Zoom.
Sure.
Christine first says this is all very helpful information to consider. And then she says, even if you have not contingent on the appraisal in the contract, but the house does not appraise, how do you move forward with your client if the house is built, it does not appraise, and without bank funding, they cannot pay the difference between the house price and the appraisal?
So, generally speaking, I find, Christine, that that's a matter of negotiation. If it's not contingent upon the appraisal, it does not give them an out. Okay, so they're still legally obligated to close that sale, regardless of how they get the money. Now, from a practical standpoint, I get what you're saying. How do they come up with it? And that's going to have to be a creative situation between, I find that the larger the deposit, the more availability it seems that they have to go find that money. If it's a $5,000 situation, then it's, you know, they go to a family member, or they go or they try to get a second, or some type of consumer financing, because they don't want to lose their deposit. The larger the deposit, the more likely that they're going to come up with it. I've also had builders that have in-house financed the difference, meaning they could only get their loan for, say, $300,000. It was $305,000. They've taken a note, a promissory note at the closing, or they did a second mortgage short term for the difference. So we've kind of had to be a little creative with some of those things, especially in today's climate, and I do believe you'll see that through next year, possibly the next 18 months, that we're just going to have some appraisal issues where just the straight value of the house and the cost of the house, and change orders. You know, people are adding and making changes, and they're doing upgrades, but it's just not equating to value to the house. So we really need to be careful about that. And the biggest thing that I've seen that helps is the larger deposit.
Next question we had is from Dennis. Is there anywhere we might be able to find samples of these contracts and clauses?
Years ago, I did a standard contract that is on the Louisiana home builders website, I believe. It's been years since I updated that contract. I believe it has been modified, tinkered with. So, I mean, I can tell you to look there. I just can't, I can't speak to the completeness of it, those kind of things. But some of the clauses and some of the things that we're talking about today, generally speaking, those clauses should be there. I believe that there's a contract labor and there's a remodel on that website. So feel free to check that out.
Perfect. And then Scott says, is there any way to protect yourself from being liable from a sub not paying his supplier, such as language in a subcontractor agreement? If so, what language?
Yes. So on a subcontractor agreement, very important, obviously, that you're going to have a lien waiver in there. You're going to say that they're responsible for paying those. If you have a concern of a subcontractor that you think has a supply problem, for example, I was notified, by a supplier that said, hey, your electrician or your plumber or whatever, kind of behind on the bills, and we don't want to lien your job or whatever. Well, once I knew that, then I talked to my sub and I said, listen, I got to make sure that these things are getting paid. So I'm either going to do a joint check payable to make sure that we catch those things up. I've also gone directly to the supplier and said, I want it under my account. And Mr. Subcontractor, you just bill me for the labor, and we're going to split these things out, just so I knew that those things were being paid. You can also require a lien waiver to be signed by the subcontractor prior to them getting their check. So if you've got your plumber, have them go by LCR, sign the lien waiver that, on job 11, 12, and 14, we've been paid, and here's your lien waiver. And then I know it's okay to go ahead and to pay him. But definitely, I recommend, and I'll go ahead and just jump to the subcontractor. We also did a general contract for the home builders, which we titled a master subcontract service agreement. Because we're going back to the real world, legal world, that kind of thing. I mean, I know how we contract in a normal scenario with our subcontractors. Generally speaking, we use the same guys. We've got years of relationship with these guys. And so I know that it's not practical for you to sign a contract with this guy every single time. I mean, if I'm building 100 houses a year, my plumber's the same, I know what the price is. I know what, I mean, it is what it is. I mean, I call him and say, I need you to go do a rough-in on Wednesday on whatever. I mean, he just comes and picks up the plans, and that's just the way it goes. So the paperwork, I know, is hard for you guys. So what we did, we also on that website is a master subcontractor agreement and master services. And it basically is going to outline your relationship with that subcontractor, meaning he's got an obligation to pay his bills or the supplies and hold you free from liens. He has an obligation to follow any OSHA requirements. He's got an obligation to follow any code requirements. He's got an obligation, you know, to take care of any damage that happens on your job. I mean, how many times do we go out there and, I mean, somebody falls through the ceiling and this and that? I mean, you know, or whatever. I mean, they end up putting a paint rag on top of the granite and staining it. I mean, all of these things happen. And that master service agreement covers how you're going to do business, when you're going to be able to back charge them. Probably one of the most important things that's contained in the master subcontractor agreement is a clause that basically talks about warranty. You know, there's a little bit of a misconception in the construction world that your warranty from that subcontractor is a 1-year warranty of workmanship, right? I mean, you hear that all the time. It's 1 year, oh yeah, here's my warranty, it's 1 year and whatever. So, you know, what happens is from the builder's perspective, let's talk about the AC. You know, an AC guy may say, well, I installed that unit, you know, last June. You got a spec sitting on the ground. You know, they don't move in till 8 months later, right? A couple of months down the road, somebody's got a problem, and then somebody goes, well, I installed that over a year ago. You're out of warranty. It's a 1-year warranty of workmanship. That's generally not the case. Unless you have a contract that says that the warranty is 1 year, it's really 5 years. Okay, there's a obligation for workmanship quality issues or defects for 5 years. People don't get that. So unless it's on their invoice somewhere, unless it's stated somewhere that it's 1 year, know that you are negotiating down. Okay. In that master service agreement, we specifically put in to protect the contractor, the general contractor, that the warranty for that subcontractor will be to whatever extent my warranty is to the owner. Meaning, whatever that is. Let's say that if you're the foundation guy, or you're the concrete guy, or you're whatever that is. If I have a structural warranty on that house for 5 years, you are going to warranty it to the same extent that I have to warranty it. Because what was happening was their warranty was running out, and I'm still legally required to warranty under the minimum mandatory, non-waivable new home warranty act items. Okay, so as long as you have that just one sentence in there, you're covered. You're not gonna have any gaps in between what they provide and what you have to provide for your own. Okay, so that's a very, very important reason to have this master services agreement signed. And look, you sign it one time, put it in the drawer. We don't have to have it for every job. It's continuing obligations. It's set up for you not to have to do a bunch of paperwork. That was the goal in mind for doing so. The second thing that is very important to me for the master services agreement from a subcontractor perspective is that of workers' comp. And so let's say that workers' comp is basically a trade-off, kind of like the New Home Warranty Act, in the fact that if you are deemed a worker, you can't sue your employer in what we call tort. Think of tort as your general car wreck type thing out there, the slip and fall, that kind of thing. Tort is wide open. It's whatever injuries you have, emotional distress, personal injury, economic damages. The damages are just wide open. So it's whatever it is. If you were deemed to be an employee of that employer, you can't sue them in tort. You are in a different body of law, just like a homeowner can't sue you in tort. They have to sue you under the New Home Warranty Act. So think about them as in umbrellas of where you are. If you're outside, they can sue you for whatever they want to sue you. And it doesn't matter if they're a direct employee of yours, Roddy. So if you have this master service agreement, there's a provision that's called a statutory employer. And in that contract, you can say for any damages that occur to you, Mr. Subcontractor, or your employees, I will be deemed to be the statutory employer of your employees, okay? Because think about it, roofer goes out, he's on your roof, he's the employee is of Premier Roofing, or whoever it is, right? He falls off the roof, he gets hurt. It's a workers' comp claim, and he's got the roofing company under the workers' comp claim. If you do not have this designation as the statutory employer, so this is where words really matter from a practical standpoint. If you don't have this designation, then guy that fell off the roof, Roddy, comes and sues you for an unsafe job site because you had 2x4s on the ground. Well, what job does it, right? But it is up to a plaintiff's attorney who will very artfully make that distinction that you were unreasonable in your risk, and he is allowed, this employee is allowed to sue you in tort. And it's generally a lot of things that we don't have coverage for. It's a very, very big exposure. So if you claim that this subcontractor and anybody on that job, in the event that something happens, I'm a statutory employer, all they can come after you is in workers' comp. Now, I understand that we don't want our mod rating going up. We don't want claims being made on our workers' comp and all that kind of stuff. But let me tell you, when you're talking about a liability exposure, the difference between getting sued in tort in a regular court case and having a claim on the workers' comp, because then your workers' comp company is going to fight it out with the owner and the, you know, the roofing company and all that. He's not gonna double dip. He's, whatever, they're gonna portion their thing, and it's at least a controlled burn. So, you know, just be mindful of that.
So, you have them sign off on the paperwork and so forth, but you're dealing with the main head boss man. He's gonna have 4 or 5 people under him that didn't sign off on the paperwork.
Right.
So what happens if they get hurt?
Doesn't matter.
So as long as you deal with the boss man. What about all these homeowners that got damaged from the storm, and they have people come in and do work on their job, and they're just a homeowner, they don't have any kind of extra insurance, or they put themselves at risk?
Absolutely.
These people come in here, they don't even ask them if they got insurance.
Nope.
Well, how can an individual homeowner protect themselves when they hire people to come in and do work?
They can't. They need to hire a
So they
professional, and they need to
can't.
hire a general liability contractor.
They don't even
They
think
need
about
to hire a general contractor that has proper license and insurance that can protect them from their claims. And that's where, you know, the value, and I get it. We have guys out there that are unlicensed. We've got them that are just jacklegging everywhere, and they, you know, all of these things. And that homeowner wants to think that nothing's going to happen. But the fact is, they are paying for protection, and they're paying for your license, they're paying for your insurance coverages, and they're paying for you to contract ahead of time to try to control those.
Right out here on your Interstate 10, about 25 years ago, because I'm a good old boy, I stopped to help an elderly that had a flat tire, and her spare was flat. I said, no problem, I'm gonna go get it fixed. Jacked the car up, and while I was gone, she's sitting in the car and wiggling it around. When I came back, it had fallen, and the jack did damage to her car. And she said, what are you gonna do about fixing this? I said, well, I don't think I'm gonna do anything about it. And he got a little complicated there for a minute.
Yeah, well, and that, I'll go back to that, no good deed goes unpunished.
Yep.
So before we leave, the subcontractor agreements, is there any questions on that? I'm gonna look.
We have one more from Jennifer.
Okay.
She's asked, please cover how to make sure your lien is filed correctly. Thought you just filed your contract.
Yep, we will get to that.
Okay.
And let's see, on the subcontracts, before I leave that, we talked about the master service agreement, indemnity, hold harmless agreement. Generally speaking, I put something in there where any damage or anything that they cause, they're gonna indemnify me or hold me harmless. They're gonna pay my attorney's fees. If you get me in a mess, you're gonna pay for it. Then we talk about the New Home Warranty Act provisions, make sure that the warranty tracks to the same extent. In some of these subcontracts, especially for you guys that are doing commercial work, be mindful of, there's generally a clause, and it's in the payment provision section, and it's called a paid when paid clause. It's also called a condition precedent, meaning I have to have this condition occur first before I owe you the money. And so commercial contractors, it's in their standard agreement, and they generally will let you write that out or modify the contract. But a lot of people don't understand what it means whenever it just says, as a condition precedent, payment will be made within 10 days after we receive payment from the owner. So that sounds nice, and it sounds like an obligation for the contractor to pay you within 10 days of being paid. But what it also means is the owner has to pay them first before they legally owe you any money. And so from a practical standpoint, how it shows up is, let's say I had a job out at LSU one time, and it was over the football fields and parking lots and all kinds of stuff. I ended up representing like 20 some odd contractors and trying to get payment because they weren't being paid, because the general contractor and the owner, LSU or whoever the systems plant or whatever, had a problem with some light poles. I mean, it had nothing to do with the scope of work from a landscaper, sheetrock guy, it just had nothing to do with that. But that's not what it means. So if the owner does not make payment, and if they hold up payment based on something else, that's fine. They can totally do that. So if you're doing commercial work, just be mindful of what the paid when paid clause truly means to you.
We had Sean raise his hand, so I'm gonna let you unmute yourself, Sean.
Hey, so talking about warranty work and subcontractors, I had a situation recently where a plumber in the main trunk line of the plumbing, which backed up all of the water up into the house and ruined a pretty significant portion of flooring. Of course, there was all kinds of additional damage that was dealt with. How can how can I protect myself, and what's the best way to go about, this was with a plumber that I have an ongoing relationship with, and of course he came out and did the repaired the plumbing work and did whatever he needed to do there, but then getting all of that additional work, what's the best way to approach that and protect yourself, but also like manage that relationship and deal with that situation, because I definitely came out on the losing side of that situation.
Right. And that's a pretty common thing. We have that happen a pretty fair amount, actually. So we're back to the subcontract. Obviously, if it's going to say, if you've got your hold harmless, you've got your indemnity, it's going to cover you for any damage, meaning the damage to the lines, any consequential damages, flooring, moisture, sanitation, any of those type things. And
is that something that I should have approached the general liability policy? Or what,
Yes, I would have asked the plumber to obviously come fix it and to fix the damage. And so technically it should be, hey, I've got this problem, come fix it, come fix the damage, put your insurance company on notice, make a claim for us. And we expect, obviously, you're in the middle, right? So you want to try to appease and satisfy your customer. So you're basically going to say, you got 10 days to fix it, or else I'm going to have to fix it, and then I'm going to have to bill you for it. Because a lot of times our contractors get put in a time pinch on how, it's like, okay, well, when am I going to get around to it? We've had that situation like with some HVAC subcontractors, during August. Well, yeah, I'm going to come fix it, but it might take me 3 weeks. Well, that's just may not be timely or acceptable.
So which clause did you say you said something, I want to write this down. I'm probably have it in there, but.
So you're going to look to your indemnity and your hold harmless clause. And if you pull up that subcontract, you should have some language that should help you out there.
Okay.
And then, you know, like their warranty or there should be a lot of different clauses that cover it, meaning your warranty, your insurance requirement, and just basically, you know, you're gonna follow and you're gonna take care of any damage.
Okay.
And it's
That's
usually
that's the subsequent damage issue that, you know, that I wasn't sure of.
And it's generally covered under subcontractor obligations.
Okay.
In that,
Thank you.
in that section. Sure.
Put you back on mute, Sean. Thank you. We also have Amy. You go ahead and unmute yourself.
Okay, yeah, I do have a question from one of our members, and even if they have that clause,
Even if you don't have a subcontract agreement.
even if you don't have a subcontractor agreement,
The liability policy,
but you have their liability policy,
they still respond.
aren't they still responsible for damage?
Yes, you know, anytime you cause damage to someone else, you know, you're still liable for it. I mean, if I pull out and hit somebody on the street today, I'm still liable whether or not I have a contract that presupposes that I am. The contract just helps in the fact that we kind of already talk about our relationship and what they are going to be responsible for. The indemnification and hold harmless goes a little bit further. It's not just let the chips fall where they may, if you will, meaning I'm liable because I caused you damage. The indemnification and hold harmless is me pre-saying, I understand that if I cause you any damage or any problems, I've got to take care of it, and I have to hold you harmless. So whatever you have to pay or whatever you got to fix it, you know, any of those things, I'm going to reimburse you for it. So I'm just agreeing ahead of time to do it. So it just saves you a little bit of that legal determination as to who's responsible and who's not. But yes, that's why we also provide, and before you need to pay these people, you need to have their general liability certificate and their workers' comp certificate. In the event that they don't want to make a claim on those, the address, the contact, everything is on that certificate, and you can send them a letter directly. You do not have to wait for them to do it.
Thank you. And can y'all still hear me?
Yes.
Okay. So one more question is, do you have samples of these documents that you're talking about? Do you provide samples of those online?
You don't, like I just said, I did some of these agreements for the state association. And I believe that they are still on the website.
We'll get that.
Yeah, they're gonna go ahead and pull that up and see what's on there and what's not. Like I said, just with the caveat, I mean, it's been a long time. I think they've been modified somewhat. So please be careful, look at them, get with your lawyer, see how it fits for you. You know, it's nothing that's too complicated. We just need to make sure that you're using it in the proper way in your agreements correctly.
Got
So
it. Thank you.
I just can't sit here and say that, hey, it's a perfect clause or what. I just don't know how it's been modified. But generally speaking, the base verbiage should be there for you guys to kind of look at and evaluate.
Thanks.
Before I leave the subcontract agreement, you need to be mindful of how you are contracting with your owner. in the event that you guys are requiring a mediation or an arbitration, some people are requiring arbitration rather than litigation. Some people are saying we're going to mediate a case prior to litigating, prior to arbitrating. Those are differences that we'll talk about, pros and cons in just a minute. However, you just need to make sure that whatever you've agreed to with your owner, just like the warranty, is consistent with whatever you've agreed to with your subcontractor. Meaning, if I agree to mediation or arbitration with my owner, then I need to have a clause in my subcontractor agreement that says, you understand that I have, or that you will participate in a mediation or an arbitration if requested by the contractor. Because, you know, if that's not said, then you can't force them to the game. So let's say, if we go back to, I believe it was Shane's example about the plumber, and I'm mediating, or I'm trying to figure out those damages, and we have to go to an arbitration or what have you. If I'm in that with that owner and I don't have the plumber saying that he will participate, what that would require me to do would I'd have to go through the arbitration, get whatever award that is. Let's say the homeowner wins and they go, yep, you need to fix my stuff and it's $20,000. Rather than having the plumber sit there and get it all done at one time, because he's agreed to do that, then I would have to take my $20,000 and then file suit against the plumber and say, hey, plumber, because you didn't, you messed up the trunk line, then, you know, I ended up getting hit for 20 grand over here for floors and stuff. And so now you owe me 20 grand. And it's just cumbersome. Legal services are expensive. And it just gets to where it's not feasible for you to go through and try to collect those things. So we want to try to shorten that pathway to making yourself whole and getting some recovery. Other than that, subcontracts always have something about verbal change orders or requests from the owner. You know, we're constantly in that flux, in that situation where, you know, owner comes out and says, oh yeah, I want to change this, I want to change that, and basically a requirement that they have to go through you before they're entitled to any kind of increase in cost. So any other questions on subcontracts?
Yeah, I do have another question from one of our members here. And what he's saying is, if the attorney fees are more than the repair and the plumber leaves, I mean, then there's no real, how do you recoup that, or do you? Am I explaining that well enough, Mr. Sedgwick?
Yeah,
okay.
Can you say that again, please? I just want to make sure I understood it.
Yeah. Tell me exactly how to say it. If the attorney fees are more than the repair cost, right? And the plumber in this example just disappears.
Okay.
Then the builder is left, with two bills, with fixing and with the attorney's costs. Correct?
Right. Well, I would, in the subcontractor agreement, there is an attorney fee provision that you would be able to recoup whatever attorney's fees that you spent, or that you would be entitled to that. But, you know, then it becomes a practical matter. And just because it says it, is it practical, right? So can you come and hire me to go after a $5,000 problem? You know, the reality is probably not, right? So what we have, and what I try to counsel my clients on doing, is to set that plumber up, meaning the proper demand, come fix it, and put the insurance company on notice. Hopefully you get paid from the insurance company. If not, then I encourage my client to go ahead and do what they have to do to pay and get the repairs made. And then you can make an economic decision as to how much is it. You know, is it 5,000? Is it 10,000? Obviously, the more money that you're out, the more it makes financial sense to hire a lawyer. And sometimes when you've set it up and you have these documents in tandem and it's there, it's very easy to prove a claim. Meaning that trunk line went bad. Here's my flooring receipt. Here's my, you know, the new plumber bill. Here's what I'm out. And you know, they've increased the jurisdictions of your justice of the peace courts. They've increased small claims court to where, you know, if you have a working relationship with an attorney, that basically that attorney is going to say, here's your letter, here's how you set them up, let's see how much you're out, let's go ahead and get your customer taken care of, and then here's the little form, we're going to fill it out, go to the justice of the peace, and you could probably go and convert that to a judgment fairly economically yourself, to recoup some of that money. Obviously, the more money is that's at stake, the maybe you know, the more likely you are to go ahead and pay an attorney to do it for you. Does that answer your question? I mean, I know it's generally an economic cost-benefit analysis, because you know, you want to have this paperwork in the event, and I understand the practical matter of, you know, sometimes it's just not worth you chasing around, you know, a couple grand. I mean, it's not worth you paying me. It's not worth your momentum. It's not worth your warranty. It's not worth your customer service expectation. And that's why customers do it. But what we want to have is this paperwork in place and the process in place, because when it is a Chinese drywall situation, when it is a big situation and it's hundreds of thousands of dollars, yeah, somebody's got to pay for it, and we need the I need the clauses to be able to fight for that and to be able to recoup that money and make somebody else pay for it. Does that answer the question?
Yeah, Sharon, thank you.
Okay.
We haven't had any other questions come in yet, so.
Okay. All right. Okay, so I'm going to go ahead and just, since we've had the request for the talking about the lien law, let's go ahead and make sure we get that covered. So the lien provisions, lien law provisions are very important, especially in today's climate. And this really kind of goes along with our whole new normal about the escalation clause, all of these different time things, final payment. That's what we're seeing the most of right now is warranty and final payment issues. And people are moving in that house, they're out of money, they're out of a job, they're, you know, I mean, I've had more requests to buy back houses and, you know, which isn't even a availability or a remedy under the new Home Warranty Act. It doesn't matter. People are like, well, I'm just not happy with this house, and they're trying to play to these, you know, customer service, and you ought to just buy this house back from me or whatever. Well, it really comes down to the fact that these people are out of money or they're out of a job. And so it is making our final payment very difficult. And here's the thing, the law provides you guys a remedy to be able to lien that job, but it requires you to do certain things ahead of time, okay? And not after the fact. And so if you do not have this process set up, you will not have a lien right, period, paragraph. So if, you know, let's say that, you know, people always talk about, okay, well, how do I feel like this person's getting squirrely on me. I can tell. I mean, you can tell as they start to move in, you know, everything's been great. You've been kind of giving along the job. You've been kind of helping them here. You're not really charging them full fare for this. And, you know, we're getting used to, we're kind of coming towards the end. And you just kind of have that feeling that things are getting a little bit, they're just getting a little squirrely on you. You can kind of tell. Now is not the time for you to consider doing a lien, because everyone else has a lien right, meaning a subcontractor, a roofer, a laborer, a bricklayer. It doesn't matter. They don't have to do a thing. All they have to do is go timely file the lien. A supplier, same thing, timely file the lien. Now they have a notice requirement. They have to give you a notice requirement, or the owner a notice requirement. But generally speaking, a laborer can just go and file the lien and protect themselves. As a general contractor, if you do not file a notice of contract or record your contract prior to the job beginning, not at the end of the job whenever you feel like they're getting squirrely and they're not going to pay you. Prior to the job beginning, if you don't do that, you do not have a right to lien that job.
Question on liens. Help me out here. I'm trying to understand. Just because you file a lien because of non-payment, how exactly does that put any money in your pocket?
So it's a matter of leverage. It's a matter of leverage, and it's a matter of negotiation from a practical standpoint. From a legal standpoint, you properly file your lien, right? You properly make your case for the right amount owed. It acts as a mortgage on that property, okay? It gives you a claim against the property and a claim against the owner for the money that's owed. So think of it as a first mortgage, second mortgage, third mortgage, whatever, okay? And in a case where somebody's paying cash for their house, when you file that lien, you're the first mortgage holder. You could seize that house and you could sell that house for the lien amount, as long as you properly perfect the lien, okay?
What if the homeowner chooses to just not pay you? What do you do then?
You can seize it.
You can seize the property.
Absolutely. So there's mechanisms that you do it. It's called, the lien law is a Private Works Act, and it's called a strictly construed statute, meaning it's a technical statute and it's got to be followed to the T. Not a lot of attorneys deal with it. It's one of those things. It's a very poorly written piece of legislation. It's not very long, but every single time you read it, you get something different out of it. However, just know as a general contractor, you must file a notice of contract prior to the work beginning. Meaning you can do dirt work, that kind of thing, but you just can't, you don't want to set your form or start that digging process. I have, and I've given the folks here, what's required is that you file, you record your contract. Now, most of us don't want to record our business. We don't want to record what contract you're using. You don't want to record all of the ins and outs about that. I have what is here is a form, is a notice of contract form. It's condensed, fill in the blank. It is 1 page because you file this in the mortgage records and they charge you by the page. So you don't want to go filing a 10-page contract on a job that you're going to spend $300-400 in recording fees. So you're going to spend a few bucks, you're going to record this.
The city or the state?
The city. In the parish where the job is located in, not where you're located in. If it's in West Baton Rouge, you're going to go, you're building it in West Baton Rouge, you're going to file it in West Baton Rouge. East Baton Rouge, East Baton Rouge. Lafayette. So here's your notice of contract. If you do this, if it all goes wrong, you still have a right to lien. If you don't, you do not have a right to lien the job. Now, once I lien the job, let's say I know we do this all the time. Sharon, I feel like, all of a sudden they're saying, well, I really don't have any extras, right? I don't, I'm getting ready for my extra bill, or, we're closing out. They're getting a little squirrely, and contractor's getting a little concerned that he might not get all of his payment. Do I stop work? Do I finish? Do I let him move in? How do I get myself out of a jam or anticipate it? And so if I had this notice of contract, think about it from a negotiating standpoint from me. If they're going to close on that loan, and you're right, most of the time, Roddy, they'll sit there and, all right, whatever, I've moved in, I've closed my loan, you got a lien on there, I don't care. Just let it sit there. You're not bothering me any, right? However, if you do that before they close on that loan, you're going to force a conversation, because the banker is not going to close on a permanent loan. The closing attorney is not going to close on a permanent loan. They don't care what the dispute is. They just know that there's one out there. Their title insurance is not going to cover that. They just say, I don't care what your problem is. Y'all need to get it straight. So as much as anything else, I do have the legal right, and I've got a system that's set up for me to take it, file a lien. I have a year to perfect it and to file suit on it, convert it to a judgment, and I can seize, I can collect, I can do just like any other judgment, and that's a whole legal mechanism. But more than anything, it gives me the ability to negotiate this situation, get the payment up front, avoid the lien, avoid the lawsuit, get you paid, and get out of the situation before it becomes.
Okay, this is gonna be a dumb question, but I'm gonna ask it anyway. If the property is in the builder's name, I'm assuming you can't put a lien against yourself versus the property being in the buyer's name?
Well, and in that case, I'm not gonna go to closing unless I'm getting paid.
Okay, I figured it's a dumb question.
Right? I mean, I wouldn't have the need for it unless I allowed them to close with owing me money, which I'm not gonna do that.
Just with all the knowledge you have, just kind of help me out a little bit. I've always been told that you can put a lien against someone, but if they never choose to sell their property, that's pretty much the end of it. It'll never go anywhere.
Well, that's not exactly
You
true.
can refinance.
Yeah,
If it's done
anytime,
correctly.
anytime that there's a refinance, anytime that there's a credit check or I mean, you know, it's out there. It is a mortgage. And if you perfect it, if you follow the procedure, it's just like a first mortgage. It's just like a second mortgage. It's like, you know, having a mortgage on a car. I mean, it's got to be cleared up at some point. Now, you're right. Most people, if they just sit there, they don't have a financing need or whatever, it could just sit there. But I've had them sit there, Roddy. They're good for 10 years, and you can reinscribe them for another 10 years, which is just a little form. And I have had a judgment that has sat out there for almost 20 years, not done one thing, It's a $10,000 judgment. And by the time it got through with interest and penalties and everything else, these people had to go sell and they were refinancing. They owed me $40,000.
Yeah.
And the client made the decision that they did not want to spend the money to chase that around, right? They just said, let's perfect it, let's put it on the books, and let's leave it be, and we'll just take the wait and see. If I get something, I get something. If not, not, right? They weren't going to actively pursue collecting on this thing, but it ended up working out.
We have Sean asking again. I'll unmute you, Sean. Maybe.
Sean?
Okay, can you hear me now?
Yep. Hey, Sean.
Okay. All right, so you talked about recording your contract. I had something come up on a house I built about 3 years ago. They were going to finance, and they called me saying that I had to go through this process of canceling a recorded contract. And I had never had to do that before in the past. And I was curious, and, you know, in the end, the title company, you know, went through, but they called me, you know, 3 years after the process, told me I had to get an attorney and get, you know, do this whole process of canceling this recorded contract. The contract had been satisfied. They had lived in the house for 3 years. What is, and, you know, I started the process, but then they called me and said that because I had given a certificate of completion and a final waiver of lien to them, the title company was able to do something with it, and they signed something with each, you know, but
right.
with the owners. But what is that, and why would I have to do that, and should I have done that on other projects?
So in Louisiana, we're what's called a public records doctrine state. So basically, whatever's out there on that public record is basically to serve and give other people notice that something may be out there. Meaning, you have a contract with me, and here's our notice of contract, and so that's telling title attorney, hey, you know, Sean and Sharon have a contract. You might need to make sure that everything's copacetic and it's all good. You know, if nothing else is there. So as attorneys, we want to see a chain of command, and we want to see the handoff, right? So here's my notice of contract. I would then want to see an acceptance or a substantial completion that's recorded. That also serves to, one, show an acceptance, and then two, starts your lien period. So that's where it is, and all they were trying to do, there's not really a hard and fast requirement. It's mainly to satisfy whatever title attorney, and that can vary from title attorney to title attorney. What I try to tell my clients is that for purposes, one, we're going to file the notice of contract because we want what? We want the lien right for ourselves. And then two, how it helps your homeowner is when I record this, I am taking advantage of the fact that I am getting my lien period to 30 days rather than 60 days. If I don't have a recorded contract, it's 60 days. If I do have a recorded contract, it's 30 days. The only exception to that is when you record it, the general contractor, one gets a lien right and two has 60 days. So he's got an additional time frame. If you file one, then you should file the second, which is the substantial completion.
Okay.
And that's basically, it's gonna provide that level of acceptance to those title attorneys, okay? And it's generally gonna start your lien period from the 30 days. So as a benefit to your owner, that's why you say, hey, we wanna go ahead and get this recorded so we can start our lien period from running. So if you file one, you file two. They have these forms that are here. So I'm sure they can get them.
Is that something that normally would be, I'm sorry. Is that something that would normally be done by the, like, in the closing or conversion of the construction loan to permanent financing by the bank? In this particular instance, the original financing was by First NBC that went under in the middle of the project, and was the mortgage, or the construction loan was taken over by FDIC. And so then when they went to final closing, maybe that was not done, or is that something that just a lot of people, I had never done it before.
It probably slipped through the cracks, just because of the nature of your situation. You know, generally speaking, if the title attorney sees the notice of contract out, they want an acceptance, or same thing with the banks or whatever. It's just a tidiness. I mean, it's not a hard and fast rule, but generally speaking, yes, they would get you to sign that at closing.
So it's a good idea to just plan on incorporating that into my future.
Yes, and what it does for you is to close that lien period. You know, I mean, seriously, if you don't, the lien period is open-ended. So any of your suppliers, any of those other laborers or disputes, I mean, you're leaving yourself open to a potential claim to come up. That, and I'm not saying that you didn't pay the subcontractor. You know what I'm saying?
Right.
It just happens. I mean, I had a grass guy from Alabama call me one time and say, hey, I didn't get paid for the side. Well, I mean, okay. I mean, I closed the house 90 days ago, you know?
Yeah.
So we definitely want to close the loop. For you, it closes the 30-day lien period.
So then the second one's
Thank you.
called basically at the end,
Yes.
kind of closing the whole project.
Yeah, and generally speaking, like, let's say that if we didn't have a recorded contract and we were just trying to go, if I was trying to establish when my lien, am I in the lien period, am I out of the lien period? You know, generally I'm gonna go to a third party, meaning I'm going to a C of O, you know, I'm gonna go look at the parish and see when my certificate of occupancy was issued, because I mean, that's a third party saying, you know, it's done, it's completed for its purpose and that kind of thing.
So that's the only thing out there with a, like, little line in it.
Correct.
With the date.
Mhm. Yeah. And so you're agreeing ahead of time in this situation. If not, we've got to kind of figure it out. I generally like to use a third party
Record. Document.
We had another question. Daniel Jones asked, does a 2 to 10 warranty cover what is required by the Louisiana new home warranty? Does it relieve me of any future claims? Does the new homeowner contract them directly for any claims, or do they still contact the builder? At minimum, it seems to lay out well what is covered and what is not. Want me to separate some of that?
Yeah, so, okay, 210.
Oh, 2 to 10? Yeah, 2 to 10, sorry.
Right, 210 is an external warranty. Your legal minimum mandatory requirements is the New Home Warranty Act, which is a 1, 2, and 5-year period. So the 210 is a little bit more expansive than the New Home Warranty Act. Nothing it says that you can't contract for more than what your legal minimums are. You're not required to provide them with a 210 warranty. The interesting question about the 210 opposed to the New Home Warranty Act, which I mean, we've had the claims made. We don't have a reported appellate decision on this as to whether or not it expands your warranty, because generally speaking, it is a 10-year structural issue. 210 does lay out pretty well that, hey, you're supposed to be making the claim through the warranty provider and not so much the builder, but I don't believe that it in any way takes away your responsibility under the New Home Warranty Act, because it does dictate that it is the minimum mandatory warranties.
Does that cover everything?
And it does say in the New Home Warranty Act that you can provide insurance coverage for such as that, as far as like a 210 warranty. And I guess I'll leave that to you to see if I answered this.
Deanna, you can chime in if you would like to. You can raise your hand or I can unmute you. If you have any more questions, perfect. This is Daniel.
All right, can y'all hear me?
Yes.
Good morning or afternoon or whatever it is. Yeah, so I'm a new home builder, and so I'm looking into this, and I've had other builders tell me, yeah, and one of them told me he does this all the time because it just takes away from, and I haven't had any problem with this yet, but maybe the home purchaser, I don't know. I can see lots of frivolous things coming up and people want me to go back and fix little frivolous things that really aren't part of the new home warranty, really aren't part of anything that the builder should be responsible, but it just relieves that burden from me from answering all these. And unfortunately, fortunately or unfortunately, I'm kind of a nice guy. I want to go fix everything for everybody. And I know I can't do that. So it insulates me from the owner and buyer to not feeling, I guess, like I have to be such a nice guy and go fix everything for them. And somebody else can be the bad guy and say, no, this isn't covered on the warranty. This is something you need to take care of.
Well, and Daniel, I think that's it's a very common problem, especially when we're talking about smaller companies and mom and pop shops. You know, I guess it's just human nature. I mean, I would have a much more difficult time telling my client or my direct client no. It's much easier for me to advocate on your behalf. You know, you're that middleman and you're advocating on someone else's behalf. It's hard for our builders to sit there and say no. Because the buck stops there. You know, it'd be different if we had large organizations and we had middle managers and customer service reps, and you know,
Exactly.
we had those layers in between to be able to tell that customer no and to act like it's a policy. And you know, from a comfort level, as you know, we grew in our business. You did, whether or not real or perceived, you did have to come up with what was hey, our policy is not to let people move in without paying us first. Our policy is, we don't take care of that after 6 months, or we don't take care, our policy is. And so, some people accept it better than others, but it was probably one of the hardest lessons that I had to deal with, and I think it's probably one of the hardest for our contractors to do, just because of the nature of the business, and you generally are nice guys, and you generally want to take care of these people. So,
and there's some other things like, I did some remodels before I started building houses, and there was some work I did in Riverbend subdivision where they have groundwater soil that moves. Groundwater water comes up through the ground through the slab of the house, and I saw firsthand experiences, and so I could see in some of these areas that I would, obviously I can't. We can do the best we can and get soil testing and all that, but I can't guarantee everything that would happen with slab cracking or foundation moving because of ground movement or groundwater movement. So it would be nice to have an insulating layer between me and the owner that says, oh, no, it's in here. It says that these things are extraordinary circumstances, and the home builder can't be held liable for these groundwater swells and shrinks and that type of thing.
right. And
The question I'm looking at is nuisance issues, and in bigger issues, what kind of protection do I have?
nuisance issues.
Well, like we talked about before, just insulating from lots of small calls of, 5 years, 3-4 years down the road. Well, paint is, the stain we used on the front columns is fading. Well, it's in direct sunlight. It's going to fade. It's only covered for a year, right? And I can't go back and re-stain your front columns every 3-4 years. So that's what I'm calling a nuisance issue. But then major issues of, the slabs cracking and dropping because of where you wanted to build your house. And there's a language, at least I saw a while ago, in the 210 warranty. And I don't know if it's I assume it's in the new home warranty act, that there's some kind of provisions for that, due to ground movement or something that may not be covered.
Yes. So the New Home Warranty Act provides that you can exclude damage for soil movement. However, if you don't, the reverse of that is saying that you are responsible for your soil movement. So obviously, one of my provisions and first on the list in my contract is a soil movement exclusion for your contract with the homeowner. A lot of, Daniel, where Ronnie and I tried to do some of these caveats, or what I call customer expectations. I had my contract, and then I would have a specifications sheet. And basically how I developed that document over the years was to sit down and just think about the process of the job, right? Meaning from site development, you can address how you're going to do the pad, what kind of compaction is done. All of the things that I was talking about, like hardscape, or whether it was washed aggregate or brush or broom finisher, any of those things that I was describing what I was given to my customer. Like, for example, I would put in a caveat, customer acknowledges that all concrete cracks and surface cracking and concrete will not be covered or subject to warranty. Let's say I had a custom front door. What happens? I mean, you got raised panels. What happens? They check. They're gonna split. Customer understands that you know, custom cypress doors can check or crack or what. I mean, you know, it's an inherent quality of those things. So I would try to control those expectations or put in those caveats of what could happen. I did that generally in my specification sheet.
Okay.
And then I used my contract to cover my biggies. And so I'm going to run through these provisions that I kind of want you guys to just run a checklist. Like I said, you can pull up that sample contract. You can look at some different language, but these are just the clauses that I want you guys to have in there. But I do believe that it's a great idea to manage customer expectations and those type things through a specification sheet, if you will.
Okay. Yeah, and I'll excuse me, I'll definitely do that. But I guess I was thinking more also of legally in the future. I mean, they may sign off on their customer expectation sheet, and 3 years down the road, they've kind of, it's filed away somewhere as they've forgotten about it and don't remember what they signed. And so I'm just trying to figure out, is the 210 warranty cover everything? That's best I can tell, it does everything that's required by the LA new home builders warranty. And I'm looking on some of the stuff for the home builders warranty, and it does exclude, you know, things like damage due to changes in the level of the underground water table that's not reasonably foreseeable, that type of thing. But so
it generally cracks. The difference I found is that the 2 opposed to the 5.
Right. So it actually covers more than what's required.
That's correct.
Okay.
Okay.
Thanks.
Sure, you're welcome. Let's see.
One more question
Sure.
come in. What should be filed on a spec house to end the lien period?
On a spec house. So one that's just going to be sitting. You can always file a notice of contract with yourself. You know, and a lot of times people have, like, if it's, I may have my development company, RNS interest, and then Kyle Construction is building the property. So I have my notice of contract. Same thing, you're just going to file the substantial completion. So same documents. You're just changing out the names, and they can be one and the same.
That was an anonymous attendee. So if you have any more questions, you can type it in or raise your hand, and we'll get you on here.
Okay. Before I leave the required paperwork, the Truth in Lending Act, which is right behind the New Home Warranty Act, requires us to give our clients a notice of lien rights. And this is maybe not the situation of a spec house or those kind of things. I would just get in the habit of giving them the New Home Warranty Act, signing the contract, giving them this notice of lien rights. Again, I've provided it to the Home Builders Association here. This comes straight out of the code book. It is a requirement that we give it to every single customer. And I will tell you, probably 99.9% of you haven't seen it, don't know what it is, and they don't do it. So please stick it in your paperwork, give it to your client. What it does for you is it explains to the homeowner that a lien could be filed on your job. not to your fault, not to the contractor's fault, meaning I could still pay everybody, but you could still have a lien pop up on your job. And there's ways that you can protect yourself if you would like to do that. You can request for me to bond. You can request for me to buy an insurance policy. You can, whatever. These things are never done in a residential context. Maybe if we're talking about a $10 million project, maybe, I mean, where we're getting into some more commercial applications. But basically you're just, and you know, the homeowner's not gonna pay for the insurance, they're not gonna pay for the bonding. It's just that you're legally required to tell them, and it absolves you of some liability in the fact that whenever, let's say it does lien, or somebody does lien, and then they want to turn around and go, Sharon, you didn't tell me, you failed to give me this notice, and so I could have protected myself, I didn't protect myself, and now you're responsible for that, even though I paid the guy. So we want to add this into your packet of must-have documents, okay? So I am going to run through kind of briefly because basically this is a 4-hour course. We have about 50 minutes of instruction time per hour, which kind of gets you to somewhere around 11:30, 12 o'clock, and I know we're scheduled for 1:30, but I don't want to keep you guys unnecessarily long. I know it's kind of, this is not the most riveting of information. I like to think that it does make a difference in our practice and the way we do business, but I get it. It's Tuesday and I know y'all are hungry, and so anyway.
I don't know, it's kind of one of those, the less you know, the more you know, the less you know.
Right. Sometimes ignorance is bliss, and we like that. But you know, sometimes you just have to do these. So what I'm going to do is, if you just want to take some notes, I'm going to just list briefly the kind of clauses that I would like for you to have in your contract. I will touch on them just a little bit. Not full verbiage, but I just want you to be aware that these are the kind of checklists that I believe is important that you either check the box or not, depending on how you do business. Number one is a soil movement exclusion. Daniel, we'll back to you on that. I have a clause that says that, you know, they're responsible for any compaction test. I'm presupposing minimum standard stabilization rates, compaction rates, that I'm not responsible for any kind of cracks. Obviously, when we have settlement, it's generally in the kitchen. It's generally checking off to plumbing pipes. Sometimes we have cracks in flooring, those kind of things. So I generally have that as part of my soil movement exclusion. Change order provision. You got to have a change order provision. You need to state up front whether or not you're going to add an administrative fee, a percentage, however you're going to do that. I generally say that all change orders, whether or not they are aware of the change or the increase in costs, they are still responsible for it, because you know, it just blows my mind that educated people that are building $1 million house or $500,000 house, you know, don't understand that they go into the appliance place and they've got $40,000 allowance and they come out of there with $80,000 in appliances, and they don't understand why their bill is going up. But you know, it happens all the time. And again, I guess that's that's on the side of the ignorance is bliss on the homeowner's part. You know, they didn't, well, nobody told me that my flooring was over. I just picked it out and they, you know, whatever. So I shouldn't have to pay for it. But attorney's fees. So many of you do not have an attorney's fees provision, meaning to the prevailing party in the event of collection, non-payment. I've got the right to stop the job. If I have to collect, I'm entitled to my attorney's fees. It is going to help me when you come to me and I'm going after that final payment, and the negotiation discussion is so much different than if you don't have it. If you don't have it, then that other side knows that they can just wear us out. It's not going to be worth your while to hire me, and they've got the money, and I can't force the issue. If I tell them, well, that's fine, you're going to owe him his 40, but you're also going to owe me 40 by the time I get through wearing you out, then it might become a little bit more important for them to go ahead and settle the score. Arbitration or mediation agreement. That is a matter of style. Litigation is through the court system. Arbitration is a more informal process. The general thought process is that it's supposed to be faster and cheaper. In my practice, sometimes that's true, sometimes it's not, because you're having to pay an arbitrator to sit there and listen to the case. If you can dispose of the matter quickly, it can be efficient. So it's just a matter of, you know, both decisions are binding on you. So it's really something that you should just talk to your attorney about what they're more comfortable, what arena they're comfortable in. And generally speaking, sometimes, you know, arbitrator, the thought process may be that you can select an arbitrator that has a little bit more construction experience or business experience tailored to your contract dispute. As far as a mediation, I am a huge fan of mediation. Majority of our cases are settled through mediation. If we have the opportunity to sit down, even if I don't settle the case, it's just a freebie for me, because I can see, I'm face to face with that client. What buttons do I push? How successful am I going to be against that client? Are they going to make a good witness? What excited them? What didn't? So it's free discovery for the attorneys, as well as we're just trying to get it over with before. And so usually I have in my contracts that mediation is a prerequisite to either an arbitration or litigation, meaning let's sit down and let's see if we can't avoid this process before we get into it. So it's a good little, you know, save face type thing, and hopefully try to avoid some legal maneuver. Mold provision. The New Home Warranty Act was successfully amended to exclude mold and mold damage. However, you know, just out of an abundance of caution, in the event that any of that came back to become unconstitutional or anything, I mean, the home builders, your home builders association on the state level, local level, whatever, has just done a fantastic job of legislating protections for you guys. I mean, I know a lot of times people are just behind the scenes and they don't see the real benefit to that, but from a lobbying standpoint and a legislative standpoint, they have just done a fantastic job as to protect you guys' interests. And so I just put the mold and the mold damage in there just in the event that something were to get struck down by the courts. Okay. You need a warranty provision. Obviously, I don't expand any more on the New Home Warranty Act. I just state that it is the New Home Warranty Act. Let it stay right there. We reiterate some of the things, the mold and the personal injury damages, those kind of things that I just want in the body of the contract. Punch list procedure. You need a punch list procedure because it keeps you from just getting worn out. You know, these people move in and they want you to come next week and touch up this paint, and they want you to come touch up this paint. Depending on what you're selling, the level of service, the level of custom price range, obviously that is going to differ depending on how you do business. I mean, if we're talking about a spec home, it's 250 grand, you may have your punch list walk through 2 weeks prior to closing. They make a list, that's their final list. Everything else, we put that it's accepted and subject to the warranty, and that's it. You're not gonna probably get away with that on $1 million house, you know. So on those, we say that the customer is gonna move in, they're gonna take 30 days, come up with a final list. Y'all are gonna meet on the list, you're gonna agree on it. Everything on that list is the final punch list and subject to the warranty after that.
Question on the punch list.
Mm-hmm.
Obviously, as a builder, we would like it to all be cleared up before the closing. But for some reason, if it cannot be, does the punch list justify the home buyer saying, I'm not going to close until that punch list is done?
Nope. You know, and you have a legal obligation to comply with any of your warranty obligations. And the way I answer that is if the house is fit for its intended purpose, if you have a certificate of occupancy, it's good enough for them to move in. Why is it not good enough for me to get paid and to finish my contractual obligation? Nowhere does it say that I have to complete everything, anticipated warranty, anything that may come up prior to them moving in. If that were the case, then we could be waiting around for ever.
I mean, as a builder, we would love to be done with it while we have the key to the house and we can go anytime we want. But obviously in the construction business, the subs that are involved may not be available.
Well, and that's why I try to tell our clients that we want a stopgap. We want to try to make it as this is our policy. This is what we're doing. It's 30 days, it's 2 weeks, it's 2 weeks prior. This is how we do it. We submit this, then we meet, it's more like you're laying out a process. And I'm just saying that your process is going to be dependent on how you guys do business, what product you're selling, and what you're doing. Like I said, you're not going to get away with handing over that key to that $1 million customer. I mean, maybe, I don't know. I wasn't very good at it. You know, as far as
once you hand the key over to them, then you have to get their availability of when the sub can come in there. And they may say they can only come on Sunday after 2 o'clock. The sub's gonna say, no, we're not available then. So now you gotta.
Yeah, and that's where we say, no, it's normal business hours. We're not running some kind of Mickey Mouse, but I mean, you know, it's normal business hours. I mean, I'm not asking you to come to work on Sunday. I mean, I don't expect to be asked to come to work on Sunday, nor do my subs. So, you know, it's just, that's part of it. You know, you're going to give me a list in 30 days. We're going to agree on it. And then I'm going to give you a schedule, and that's it. I mean, and I'm telling you, the more you say it, the more it becomes strict. And I mean, there's no reason that you should be asked to go over on a Sunday to do a punch list. It's a business transaction. Plain and simple. We go back to that whole professionalism and that whole how you know, that there's expectations of how you're going to be treated. And no, I don't expect to be called at Friday night at 11 o'clock. I just don't. you can get me that on Monday morning. Payment provisions, escrow provision. I do not let people hold money prior to moving in. I had one scenario where we had a special order. It was a grill. It was an expensive item that came out. So we did an escrow agreement that I allowed them to hold that out until delivery, but it was tied to the one thing. So if somebody, let's just say that you were having a fit with the customer and they wanted to hold out money for punch list, it's $10,000, okay? Then you make an escrow agreement with line item value per item, meaning they can't take the whole list, and if one item's not done, there's my 10,000, because you will never get them to agree. It's what we call the carrot and the stick. You know, it's just a moving target all the time, and it won't work out well for you. So if you're forced to do that, seek some counsel on how to pare it down, limit it in scope and size and per item. And that's one way.
So when there is an escrow, who holds the escrow money and what triggers them to release it?
Generally speaking, the closing attorney can do that. And in that escrow agreement, that's where I would have it to say, here's 10 items. Each item has a value. As I get one done, that item comes off the list. And I can have that $400 or that $500 or whatever. It doesn't have to be tied to a total.
As a builder, we would just be tickled to death if our homeowners loved everything we did. Obviously, that's not going to always happen. And when they hire a professional inspector to come out and inspect the job, and they come up with a 20-item list, the argument goes like this: we're getting into opinions. His opinion says this, my opinion says that. How do you mash that out and make that where we're all in agreement?
Well, and that's where I think you can address it on your punch list procedure, Roddy, as to how you're going to do that, because generally speaking, a lot of these inspectors go through best practices and not code and or warranty obligations. They're two separate things. And so we completely get all the time these paid inspectors, oh, we think it should have been done this way. We can think it should have been done whatever, but that's not how we do it. And so that's where you can fall back on, well, this is our punch list procedure, and this is the process that we do. You're more than welcome to have his opinion interjected or whatever, but still we have to agree on a punch list, and we've got to agree on a schedule of when it gets done. So you just kind of fall back to that default provision. Heirs and assigns. You need it's a one sentence at the end saying that any contractual obligations contained herein devolves and falls to any of your heirs or assigns. Basically what that does is, let's say somebody dies, let's say, or whatever, it's a contract, it's a personal obligation, and it just means that contract then goes down to whoever it is, just an added layer of protection. Obviously fortunately it doesn't happen a whole lot, but we definitely need that. A right to cure, meaning in the event that there's any dispute or punch list item or those kind of things, they're going to give you notice of that before they go tinkering or fixing or whatever. They're just going to give you notice of the problem before they fix it and give you an opportunity to come inspect it and to give your opinion as to whether or not.
I hate to be just not paying attention here, but what you just said just then hardly ever happens of getting what's the word I'm looking for, a notarized, letter statement. It's always a phone call and, hey, this is not working, this is not right, when are you gonna come fix it? So legally, if you never got it by mail, I don't know, do you have an obligation? Because you never got a letter in the mail, you only got a phone call.
So the New Home Warranty Act says no. The New Home Warranty Act says that in order for it to be a recoverable damage, that it has to be given to you in writing, or it is excluded from the warranty.
Just text.
Yep, certified mail.
I think it comes back to what we call.
And that's where you get, because it's got, the builder has to be given, according to our act, a reasonable opportunity to comply with the act. And the only way that you can go back and prove it, and there's been case law about, well, he knew about it because he was standing out on the job site and we pointed it out to him. Well, the courts have said that's too vague because you might have pointed out this dormer, but really what you were complaining about was the bracing. And how is he supposed to know about the bracing? It wasn't an exclusive list. And so you're supposed to list it out, give it to the builder. The builder has an opportunity to go in, look at the list, evaluate it, and then respond to you as to how you are going to address or not address the items. So, and that is a prerequisite for it being recoverable against you. I mean, that's what that says.
I think that we're gonna always get back to, are you a responsible builder or not? A responsible builder, it can be 2 months past the warranty time, and like, come on. I mean, are we gonna really go by that? You're gonna go back there and you're gonna want a happy homeowner. Most problem that's ever gonna be brought up can be remedied fairly easily, so why not just go do it?
It is, until you have the person that's, wants you to repaint their house after 10 years and they haven't painted it. Because they said, you failed to properly prime it. I mean, so there are cases, and, majority of the time, my clients just fix it. If it is those just marginally out, but man, you got some people that are pretty egregious, and that's where you have to go back and lean on the policy and the law, and you just have to say, no, I'm sorry, I'm not repainting your house after 10 years. And I had it happen to me. I mean, it's crazy. Never painted.
This does not happen very often, but every now and then we'll get a letter or a text just thanking us and appreciating us for all the things that we did. And when you get that, it's like, it just makes you want to do even more.
I mean, certain clients have been good clients, and yeah, you want to do more for them. I mean, that's just, I guess that's just with anything.
I think it's called appreciation.
That's right. That's right. I mean, I have certain clients that are less problematic than others, I mean, and I will make exceptions for those guys and do what we need to do. Okay, so as far as clauses go, termination and escalation clause, which go back to the whole mat homes, we're back to these the things that I think are really kind of in this day and time fairly important for you. I have a kind of a sample escalation clause for building materials here, and then special circumstances, right of termination. I also, that can go in with the escalation clause. However, I always have a termination clause anyway in my in our thing, basically just saying that I'm entitled to, if I terminate, I'm entitled to my cost and my profit up to that point. If the client terminates, I'm entitled to whatever percentage, you know, that kind of thing. But that I always have the right to terminate, because when that client starts getting squirrely on you and they start demanding stuff, and you can just tell they're gonna be standing out there all day and they want you to come be out there all the time or whatever, you can just say, here's our termination clause. I don't think custom home building is really cut out for you. I'll submit you a final invoice, no problem. You don't have any legal liability. You're not gonna be subject to any kind of increase in cost or any of those kind of things. So you just want the availability to get out if you've got that difficult customer. This particular escalation clause for building materials kind of goes through the building materials. It's got a blank for the percentage. It's just to be used as a template. You can shorten it, you can redo it, however you feel fit to use it. Either that, or, you know, I think you've got to have a termination clause to where you can just walk. You have to have the escalation clause or go to a allowance on the building materials, or try to allowance most everything that you can, meaning, you know, whatever those manufactured parts are, roofing shingles, appliances, you know, the windows, the different things that Matt talked about that was outside of the commodity range. So you can either control it by escalation, allowance provisions, and fail-safe is the termination clause. Okay, so if not, then, you know, consider cost plus in the next, you know, year to 18 months. I know a lot of people like to do the fixed price, especially in a spec situation or a pre-sold situation. If that's how you're building. On a custom situation, now may be a time to get comfortable with a cost plus type scenario. But you cannot, if you do a fixed price, you have got to have it as an allowance or some wiggle room for you to get out, because you just can't take the volatility of the manufacturers or the building prices.
Well, Sharon, most of the builders that I know, they're pretty smart, they're pretty sharp in the building world. And when these lumber prices started escalating, the builders I know, they're not custom builders. They're more of a spec builder, or you come along middle ways with a spec and you allow them to buy it. When this happened, a lot of them had purchase agreements, but we're not gonna make any money. We're not going forward with it. They don't have the detailed contract that you have, but they're saying, hey, customer, it just increased by 25,000. Do you want to continue or not? And most of the time, the customer says, no, not. And so everybody resolves it without the detailed paperwork.
I'm glad that works for you.
You know, I don't know how they're getting away with that, but they're not going to do a job and not make it.
Well, some do, and some people know that, you know, if you go to them and you go, hey, it's going to cost you 25,000 more. I mean, are you going to fight about it, or do you? I mean, it's all negotiation. However, I'm telling you, I'm busy. I'm busy, and I'm busy for a reason, and trying to work people out of conversations that maybe they gave them a fixed price thing, and the people want their house done and they wanted it whatever price. So
It's binding. It's binding.
It's binding. It's real. There is a contract. You are legally obligated. And, I mean, I'm glad, hey, you want to work it out or you don't. But I mean, you know, if you sign that contract and that price is 30 grand more, then, you know, you go turn around to that client, and I go to you and I say, you want to pay 30 grand more? You go, no. I'm not wanting to pay 30 grand more. I contracted with you for a certain price.
So help me out as a builder and all of my builder friends, because we done got to a stage in our life, we don't do custom homes, we just do spec homes. So the only contract we're gonna see is the purchase agreement that the realtor gives us, which is not in our favor. So if a homeowner says, I want to do a $5,000 upgrade, here's the $5,000, but then for some reason it falls apart, they want their $5,000 back, and the house is not going to appraise to cover that. How can it be written where they don't get their upgrade back, or can it be written?
Absolutely. Absolutely. Non-refundable deposit, and it's not subject to appraisal.
Really?
All the time.
We had another question come in. John Jordan asked,
Put in the change order provision.
you're good. Is there a legal document that protects builder from third-party home inspection on new home, which is protected under New Home Warranty Act? I've had some home inspector actually tell buyer to remove GFIC circuit breakers, which is a direct violation of home inspection by government agency. The home inspection group is not a state-regulated agency.
You know, the builder's obligation is to code, and you know, a lot of my clients actually put in that that the homeowner is welcome to pay for an inspector if they want to, that they understand that that's not binding on them, that it doesn't change their warranty provisions, and you know, that they will take it and use it as a guide and address each situation, but they are under no obligation to perform what's in that report. And legally, you're under no obligation to perform that. Your obligation is the New Home Warranty Act, and you have an obligation to be code compliant, period, paragraph. And so, I mean, we get all kinds of stuff. I mean, how they want their shingles and their, you know, nailing patterns, the orientation of the compressors to the drip edge, to the felt, to the, I mean, it's just all these best practices, things that are not code compliant, they're not required. It's just over and over and over again. And these guys, their reports, they read the same every time. I can guarantee you, if you tell me an inspector right now, I can tell you what he's going to find on that property.
John, if you have any more, you can raise your hand and you can chime in as well. Do you know?
No, I was referring to what he said, if you want their $5,000 back. And you take it with that.
Well, we build a house, we want it to sell, and it's not gonna sell unless the client, but most of the time, it's not the client. I hate to say this, it's the realtor is requesting that. Because I think it makes them look good as a realtor that they have their home inspected. And in truth, as a builder, sometimes they'll point things out to us that, hey, you know what, we want that fixed. We're glad you found that.
Yeah,
Because the saw is going to come back, all it takes is one phone call.
And if it is something that fell through the cracks, then we want to know about it, and it's easy to fix, and while you got your subs in there to go ahead and fix it. Another thing, as far as the provisions, before I let you guys go, is the timing. You know, please try not to put times in your contracts. You know, as far as if you don't have a time, meaning we will be complete 6 months after slab or whatever, pouring the slab, then if that time passes, then you're automatically in default. If you don't have one, even if you say we will strive to be, or we will whatever, or failure to timely complete shall not be considered default. What that requires is, or should be, don't use mandatory language, should be, or we will strive to complete your project within whatever. Obviously, you've got weather delays, you've got shortage of materials, you've got those kind of things. So, you know, But failure to timely complete that is not a default. And that doesn't, meaning if I have a time certain and that date goes by, I'm automatically in default. If I don't, then it requires the homeowner to say, hey, you told me you were gonna be finished in 6 months and you're not. Time is of the essence. I'm placing you in default. You need to be finished within so-and-so. But it keeps you out of damages. So it keeps you from having to argue whether or not you're, whatever. Because, you know, owners make decisions late and it's on and on.
On the lower end homes, 300 and less, they're always focused on that low interest. And so they will try to anticipate what's going on out there. And then like with this job, moving really quick, without even speaking to the builder, they'll lock into that low interest rate. And like, now I've got to be finished in 6 weeks, can't be done. You should have talked to me first. But what you gonna do? If they can't get their financing, you can't sell the house.
And you know, and that's the age-old thing, and it's always something. It's the Thanksgiving, and Aunt so-and-so's coming in for Thanksgiving, and they gotta be in for them, and then they, you know, or Christmas, so then it's this, or then they got the 16-year-old birthday party. I mean, it's always something, right? And they're gonna keep pushing that date, and keep pushing that date. And the fact is, if you don't obligate yourself to a date, you're under no legal obligation to do so.
So I can tell that you're on your game with all these contracts, but you use the word while ago that got my attention. Use the word exclusion. So you can have a watertight contract, but if it's got exclusion in there 3 or 4 times, that has just weakened that contract in a big way. How should a person address all the exclusions?
See, I see it as a strengthening rather than a weakening, because I use the exclusions of the New Home Warranty Act, and the New Home Warranty Act has a complete listing of exclusions, meaning this is excluded from the warranty. And in my warranty provision, I say what's excluded: personal damage, mold, those kind of things. I see it as a strengthening because I'm taking out landscaping, I'm taking out cracks in concrete, I'm taking out soil damage, I'm taking out things that I know people are gonna ask me about, and it's not covered.
Okay? Depends on which side of this contract you're on. Scenario, I just bought a new vehicle and I want it to be warranted. The car company says, here's your warranty, but we got 5 exclusions in there. Okay, I'm over here saying that's unacceptable to me. How can I make them take those exclusions out?
You know?
Don't buy the car.
Right. I mean, and I guess that's where we go back to what I started with. It's the professionalism. And if I go and I buy a hairdryer, there's a stated warranty. If I go buy a Ford truck, there's a stated warranty. And if the transmission is only covered for 50,000 miles, you go on into Ford at 60 with that transmission out, and guess what they're going to tell you? It's not covered. It is what it is, and we accept that every day. As consumers, we accept that every day. But for some reason, we don't hold ourselves to the same policy that a normal business would. And at the end of the day, we have a bottom line to protect. And in order for you to be healthy, in order for you to be able to give the customer service and to do those things for that customer that may be outside of that warranty, customer goodwill, the Fords that cover it when it shouldn't be covered, or you covering whatever it is, you can't do it all the time. You just can't.
Here's a weakness of all human beings. Everybody sitting at this table, we all have this weakness. They put a stack of papers that thick in front of you, and they say, all right, you need to sign right there on that line. You don't read a thing. You may glance at it, you start signing. And I see this over and over, including myself. And oh, your glasses are on the floor there. And we need to get better at that, because we need to know what we're signing. Me and the people buying from me, we need to know what we're signing.
Well, and what I try to say is, you are selling a product, and it's up to you to dictate what they're signing. And too often, more often than not, we as builders have let other industries and other partners provide and dictate what we as builders have signed. And I'm just telling you, whether it's the realtors, whether it's the AIA, whoever took that time to do it, but we've just been going through the motions, we've been selling our product, we've been doing our wares, and not saying, you know what, I am selling this, and I need to know what I'm signing, and I need to know what I'm asking them to sign. And that's,
That's why you're busy.
You want us to be educated. I see where you're going.
I mean, it's kind of been the same thing. I mean, like I said, I've been a member of this association since 1992. And I've been licensed, and I have done every facet of it: development, sales, real estate, contracts, customs, had difficult clients, specs on the ground. I mean, you name it, and it is. And it's just, you kind of, it's the same kind of things every year that you say to people. And as you get further down that career, Roddy, and as where we are now, we should be able to stand up and say, this is what it is. I don't have to just take what's given to me. This is a business, and I'm professional, and we're good at what we do, and this is my expectations. And I believe that with that, your customer can appreciate the professionalism, and they will respect at least the formalities of it.
I'm kind of old school. If you don't want my house, I don't want you to have it. But if you choose to want it, I will bend over backwards and make you happy.
Yeah, I get you.
Okay, sure.
Amy, from North Shore writes in, and she'll, I'll unmute you, Amy. Mortgage lenders usually will not allow cost plus contract, but lately banks have suggested a separate addendum holding customer responsible for all costs. Is this legal? And then I'll unmute you. Oh, she's unmuted. There you go, Amy.
Is this legal? Amy, I'm not sure exactly understand. A cost plus contract is certainly legal. From the mortgage perspective, they don't like it, obviously, because there is a real risk of that consumer outspending themselves, right? So, if I've qualified for $400,000 and that's what they've got the loan for, they're just trying to they're just trying to protect their client to where they don't go spend $500,000 because they can't qualify for $500,000. There's certainly nothing illegal about it from the builder's perspective or how you contract. And certainly, just because they qualify for 500 doesn't mean that they wouldn't be responsible for 600. Does that answer your question, or am I on the wrong track?
Yeah, pretty much. Yeah, no, that answers.
It's more of a mortgage thing, and the mortgage lenders kind of want to see us more in a fixed price contract nowadays because of the qualifying ratios. But that's between them and their owner, and that's not for your benefit. You know what I'm saying?
Well, there's also a 10% contingency added to the cost of the contract.
Right.
Addendum, so they have their own 10% buffer.
Right.
Okay. Thank you.
Sure, you're welcome. Anybody else?
Right, okay.
I don't have anything coming up on my slide.
Okay, well, I thank y'all for your attention today, and I guess I'm gonna sign certificates.
We'll get the certificate sent out, and then we also have the list of files that we'll send to everybody as well, with the email that you guys have.
If in the event that I didn't address anybody's concerns or questions today, my name again is Sharon Kyle, Kyle. It's the Kyle Law Firm, and My email is sk, as in Sharon Kyle, sk, at kylelaw.net. And our phone number is 225-293-8400. So, thanks so much, guys.
Thank you.
Thank you so much, everyone. I appreciate it, Ms. Kyle.
Thank you.
Thank you.